The meeting will now come to order. May we have a roll call, Madam Secretary?
Mr. Wetterholtz? Here. Ms. Curry? Here. Mr. Jones?
Here.
Mr. Harrington?
Here.
Ms. House? Here. Ms. Hines?
Ms. Himes is absent. Motion to excuse. We have a motion. Motion from Mrs. House, second from Mr. Jones. All in favor say aye. Like sign opposed. Motion carries. Here. All right. Has everybody had a chance to read the minutes? All right, we're going to have a correction to the minutes on page 12, number 19.
Page 12.
Yeah, of the minutes for the March minutes. Case number 19, CEB 0318-31, Coalition Against Hunger. Disposition of this case. This case was continued to the April 19th, 2018 Code Enforcement Board meeting. That is going to be changed to May 10th. That was just a typo. It should say May 10th. All right, so with that correction, are there others? Any others? All right. Motion to accept?
So moved.
Motion, Mr. Harrington. Second? Second, Mr. Jones. All in favor say aye. Aye. Like sign opposed. Motion carries. Does anyone need to disclose any ex parte communication? All right. Do we have any announcements, Madam Secretary?
Yes, the following cases are in compliance. Case number 4, which is 0118.
Oh, good.
100
Okay.
Carolina Lake Drive is in compliance. 41118. Case number 12, which is 031829, 824 Congress Street is in compliance. 4/5/2018. Case number 18 is in compliance. It's 041837, 609 Casson Avenue in compliance. 4/4/2018. Case number 19 is in compliance. It's 041838, compliance 4918 for 630 Holmes Avenue. Case number 20 is in compliance. 041839 at 606 Gibson Street in compliance. 4/4/2018. And case number 23 is in compliance, which is 041842 at 1008 South Ridgewood Avenue, compliance with 4918.
Madam Chairman, I have a question for the Secretary.
Yes.
I have 2 copies of lien review number 1, and I do not have a copy of lien review number 2 in my packet.
They look the same.
Check the number on it.
That one is,
Oh, it is. It says
one says case number SMG 0207.
Oh, okay, it's the same.
Same address. Well, yeah, we'll need to figure that out anyway.
2 liens on the property.
Oh,
Okay.
all right. I got it.
Okay. Right. Would code officers please come forward and be sworn in?
Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, everyone, here's our procedure. We will be calling cases by number, and for the most part, in order as they are listed in the agenda. If there are any police officers that need to get back to assignments, we'll hear those cases first, and if there are any lawyers that need to get to court, we will hear those cases first. I know we have one case. What case number is it? 5. So we're going to hear case number 5, and then everything else will come in order. When your case is called, please come forward and be sworn in. State your name and address for the record. If you are not the owner of the property, please state your relationship to the owner. Our proceedings are recorded, so please speak into the microphone. The board hears from code officers first, and then the respondents will be given the opportunity. Please direct all responses to the board. Witnesses may also testify. So if this goes on longer than 11, then any of you that are left would come forward at 11 o'clock. We'll take a little break, and we'll take your cases of anyone that's here. And if people aren't here, we'll hear those cases afterwards. All right, so let's start with case number 5. This is CEB 0118-01. Vishnu Limited at 1000 North Atlantic. Respondent present? Okay, please come forward.
Morning.
Good morning.
Michael Cicchetti on behalf of Vishnu Limited. I have also with me Pramila Desai, who's a representative of Vishnu Limited.
Okay.
And we are waiting on Eric from R&R Roofing to come and address one of the violations here, the roof and drainage.
Okay. That person's not here, though, yet.
Apparently not.
All right. Okay. We're here today for an imposition of a fine. Mr. Klieg, or Mr. Jackson, want to come forward and talk about this?
Madam Chair, is he saying that he has more that he wants to present and not here? Did he want to delay until he had up everyone that he wanted to present?
There are some issues I would like to address.
Well, we're only going to hear the case one time, so if you want to,
and hopefully
he'll be here by the time we're
right. There are some recent developments that I should address, and that go more towards resolution of the issue. This past Friday, the property was posted.
Hold on. Let's get a background here.
Okay.
And catch up to where we are.
Okay, well, good
I'll
morning,
give you a
Madam.
chance.
Good morning, Madam
Good
Chair.
morning.
Members of the board, Anthony Jackson, attorney for the City of Daytona Beach. And as I said, this is case number 5, 1000 North Atlantic Avenue. This has been before you. It's before you today for imposition of a fine. The violations, failure to maintain roof, windows, balconies, and then we've had these continued issues of the property being unsecured and our concerns with the unsecured pool and other unsecured portions of the property. As you may recall, it's been informed that there have been issues of transients and so forth in the property, and the condition has been of challenge. Since our last meeting, they've also had a couple of fires on the property. The chief building official has issued a condemnation, and so the property is currently condemned with an order for them to remedy or demolish within 30 days, I believe is the general language of the order. The recommendation from staff regarding this current status, there has been no real change in status, nothing of any significance. And as you may recall, there's been information from the attorney, and I know there was a thought last time they were before you of maybe going for a fine, but not really understanding why the attorney wasn't present and having get that opportunity to hear why they or what they were doing. But the circumstance regarding the property, as you recall, I think there were some issues of they were having mediation, they have some insurance issues, all those things. I'll leave them to explain. As far as the perspective of the city, though, is that this property, they've done very little to protect the health, safety, and welfare of the citizens of Daytona Beach, and we understand this has been a property that's been in disrepair for now some time, and the request of the staff is that a $1,000 fine be imposed to a maximum of, and I don't see my maximum. Did you have a maximum? To a maximum of $45,000.
And the fine stops when they tear it down, according to the The ruling? That's,
Demolition would
Yes.
remedy the
Right.
violations that we have.
okay. I remind everybody, this has been going on for exactly 1 year.
And I
All right,
tend to Mr. Clegg if you have any
okay.
factual
Do you
questions.
have anything else to add, Mr. Clegg?
Yes, ma'am. Good morning, Officer Clegg. My credentials are on file. If you remember last hearing, you stated that the should have been in compliance by the cutoff date, which would have been 4/4 of this month. Attorney called me, I think about 10 days ago and I didn't hear from him on the 15th of March. He was supposed to get with the mediation. I didn't know the results. He told me that they were still having issues with the insurance company. Ironically, on the 4th, I've got a copy if you need to see the fire report that was arson to the couple rooms. Manager Sykes went out on site at about, I think, 6:30 at night and did a site inspection along with the fire department. The following day, that's when the building official got involved and issued a condemnation of the building. Nothing currently has been done. I've got more cases coming up in reference. You always suggested the pool. That's next month's hearing. But my concern was that that these permits were issued. I think the attorney is going to talk about R&R roofing on the 31st of July. The building department issued a pass for the in progress of the roofing, but an actual final was not done to the roof. So there was no. Go ahead.
My question is, didn't we ask that the city secure the pool if they didn't within
Right,
a
but
certain number?
the original citation wasn't for the pool. That's why this new citation was there, and it should be in front of you in the next month's hearing. The attorney said that he didn't think there was much water in it, but obviously this last picture you've seen. Okay.
Okay, I'm a little confused when we ask the city to do something because it's a matter of health and safety. Even though wasn't specifically on the violation notice.
Yes, two issues,
Okay,
Madam
let's
Chair,
see
regarding
that.
that. I'll remind the board and you, Madam Chair, that that they weren't cited specifically for the pool, but the way that the board addressed it was that they were required to secure the property as a whole,
Right.
which included
Okay.
making sure that the safety and security of the pool was covered. Y'all did address that, and you
Right.
did authorize the city because there's no authority for the board to order the city
Right.
to take action.
Correct.
And the manner in which the city would take those actions would start with a condemnation. So the city is taking actions to try and remedy these circumstances to protect the health, safety, and welfare of the citizens.
Okay.
Could, Officer Cleek, I'm having a hard time seeing those. Could you explain the pictures as they come up?
Officer,
And I will object to introduction of these photographs. These photographs were taken more recently.
Would you please come up to the microphone?
These photographs were taken on 4/4/4/5, and these are as a result of the break-in and arson of two of the guest rooms at the property. So these photographs do not depict the violations that this board is here for today. Now, certainly we want to work with the board, but there is a process here, and we're here today for roofs and drainage, stairways, decks, windows, skylights, and door frames. And so while I do want to have a constructive conversation, I also want to keep these issues neatly in their boxes. And if we are here to discuss this notice, my preference is to discuss this notice, and more globally, what can the property owner do to achieve a balance between securing their property, restoring their property, and doing it timely to the satisfaction of this board.
Has there been a new list of violations? Is there a new?
There is a new list, and I believe we're on next month's agenda for those.
yeah, there's a new list for the trash and debris for the pool, and also the structural members on the exterior.
And Madam Chair, if I could just speak in response to our
Please.
council. If we were at the stage of determining compliance or non-compliance, then I would agree with the council that as far as the scope of what we discuss. But we're here at the stage of imposition of a fine where now it's time for the board to look at all circumstances and all circumstances related to this property in determining what's a reasonable and appropriate fine. The egregiousness, the efforts of the respondent to come into compliance, and the overall nature of what we have here. Things like fires occurring, transients constantly staying or living in the property and overtaking the property are relevant issues in determining the severity and significance of the status of this property and the need for it to come into compliance.
Mr. Klieg, did the fire department state whether the fires were started from inside the property?
Yes, sir. It was, I got
so
the-
it's
if you
not
need to-
secure?
Well, the property was insecure, but if you need a copy of the fire department report, state in there, that it was started by arson and in an insecure room. That's why the picture I wanted to advise was where you could see the window was shattered, where the room was started fire, and that's how entry was gained.
So the property wasn't secure.
No, the
leading
property
to,
Is not secure at
It
this
still is
point.
not secure.
Still
They
not
jumped the
secured.
north fence, and they were having problems issued with by the beachside approach, where people's transients were pushing down. It's just a construction fence, cyclone fence.
and did the city tell the property owner that they must secure this property?
Yeah, that was part
So
of
that's
the,
on record?
Yes.
And they did not do it, which led
No.
to this fire?
And that's why, like I said, these windows weren't. Some of them were still busted out from the prior incident from the violation back in April, and then now recently was this April when Officer Sykes went out.
Thank you.
Okay.
I would also like to hear from the building official
Okay.
before we.
All right. Mr. Urquhart, good morning.
Good morning. Glenn Urquhart, Chief Building Official.
He was the one in with the officers.
One of the questions, that it is pertaining to this is on the roof, and you've decided for the demolition of the property. The roof inspection has gone with the city or an outside.
The inspection was done by John Bowden. It's an in-progress drying inspection, and on a roof that size, we would do in progress until we get to the point where they actually finished product. From the last inspection, there was never another inspection called in, so therefore the permit expired. So you have an expired permit at that time, and then it would be the duty of the permit holder to reinstate it or ask the building official if they could go ahead and reinstate it, but nothing was ever done on it. It was just left hovering out there as expired. There wasn't any work being done on it.
Because the permit was pulled in over a course of, what, a year is when the permit expired?
Yes, I believe. Yep.
Okay. Thank you.
You're welcome.
All right, Mr. Caccetti, what would you like to say?
First, I would like to invite Representative R&R Roofing to explain the work that was done to the property.
When? The recent work that's been done to the property?
This work, the dry-in, would have been accomplished, and I would defer to his.
Okay, well, let's hear from him then. Thank
his
you. We're going to
testimony.
move this along.
Understood.
State your name for this.
My name is Eric Freight, 31 Oak Brook Drive, Ormond Beach.
Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
And you've been hired by Vishnu Limited to do the roof work, is that correct?
Yes.
Okay. Go ahead. Tell us what's going on with that roof.
We pulled a permit. We tore.
When?
I'm not sure what the
Oh,
date.
you don't have to
it was,
have the
It was a
exact-
year ago,
A year
A year
ago.
ago.
Okay.
and we tore off the roof in, put it in a dry-in state. The only reason we didn't call
Would you explain the dry-in state?
completely covered the entire roof with a sturdy SBS modified membrane. That should last more than a year. Normally, it's the first layer of something that we put on for a 20-year roof.
Okay.
And the only reason we didn't call a final is because we're under the assumption we're going to pour lightweight on top of that and put a thermoplastic roof on top of it. So we're going to modify the permit when we move forward with the project.
When did you do the work? You pulled the permit a year ago. When did you do the work?
It's
If you
probably
recall.
about finished it about 5 or 6 months ago.
And why did you not then, at that point, go get the rest of the permit or finish the work?
The owners were wanting to tie in the mechanical work that's involved with the roof.
So
And
they-
I've been having a hard time getting subcontractors to do mechanical work. But all the roofing stuff,
Okay.
we're ready to go.
Do you have anything else to add?
Well, I have some questions for you.
Well,
Wait a minute, I have a question for the roofer. Now, you're talking about the mechanicals, you're talking about the air conditioning, and putting them on the roof. But the roof was, when you put the membrane on it, it was dried in totally.
Yes, the whole 100%.
So the mechanicals, was it shored up properly underneath of it
Yes.
to support the weight and everything? And it was just the lack of the mechanical contractor.
Yeah. I was asked by the owners to also include mechanical work, and we used to do mechanical work also.
Are you licensed?
We were.
That's not, so you're not licensed?
We aren't anymore. During that time, we closed our mechanical division.
Okay.
But he is a licensed roofer.
But not mechanical.
But not mechanical.
That's correct.
But you haven't been able to find anybody in 5 months.
No. I've gotten some people, but they never finished up their numbers and gave me a solid number and said, yes, this is what we're going to do, and we're 100%. So I've been talking to several, and they've given me several different options, but nothing that's going to bring them up to 100%.
Can I ask something about
Sure.
that?
please, Mr. Jackson.
My inspector's notes indicate that you had your inspection on the roof on July 31st, which would have been almost a year ago. Was that probably more accurate in time? Okay, not just 5 months ago.
Well,
Thank you.
In the middle of hurricane work.
Is there
And just to be clear here, as of July 31st, John Bowden with the City of Daytona Beach did a dry-in inspection. So
When?
whether or not this board finds R&R's testimony credible, the city itself has admitted that via that inspection that the roof was watertight as of July 31st. Now you have R&R's testimony that that roof is watertight for at least a minimum of 1 year. So I would respectfully submit to the board that the first violation regarding the roof, and I understand that there's 3 violations, but again, these are the 3 violations before you, and I must address them in turn. And so the first violation relative to the roof does not stand. The city's own inspector inspected that roof and gave it a dry-in.
When did they, well, I'm going
As
to
of July
ask,
31st, which predates.
I'm going to ask Mr. Urquhart this question. When did the city inspect that roof? And what did the inspection say? And when was the next inspection due?
July 31st is when John Bowden did the inspection.
Okay.
It's an in-progress inspection that he did, which an in-progress it says exactly that. It's an in-progress inspection. So they would have to call in another inspection for a dry-in to get the final dry-in, not a final. But your dry-in would be complete at that point. Then you would get a roof final. But it's not typical to leave a roof open that long. I mean, that's a long duration. Usually, even though it's a large roof, you wouldn't leave it open since July 31st. I mean, and that's the last time as far as the work being done. Here we are in April, working towards May, and approaching a year. You just don't leave, even though they're saying we did the inspection. We don't guarantee that a roof is watertight with an in-progress inspection. Any guarantee?
So it's called an in-progress inspection. And when should they have had another inspection?
When they completed the dry-in. So upon completion of the dry-in, so if they completed it 30 days later, they should have called in for a dry-in
So
to complete
in
the
your
process.
opinion, it was not, the dry-in was not complete.
Yes.
Well, now,
Hold on. Okay.
So basically, there's never been a final inspection on that roof.
No.
No. Yeah, a roof final, that's the inspection that would close this permit out. A roof final has never been called in, just the in-progress dry-in. And we do in-progresses to accommodate people because we work in a rainy state. So you get an in-progress, but you still have to finish that dry-in inspection.
Okay.
You know, and the contention is what they're saying is it's viable for 1 year. Yes, it is, but it's not complete. It was never meant to be exposed for that long. Even though that you're saying it could be viable, but under weather conditions, it's never been approved for being that long, and I'm well familiar with the material.
As far as Florida building code.
Please, if you're going to testify, please come up here. Thank you.
Florida product approvals, you're correct. That's according to Florida product approvals. But
Absolutely.
the only other inspection that we're required to with that permit would be a final. An in progress and a final.
But
And
says-
in progress and a final is what I heard you testify
And
to.
an in progress and then a final to close out the permit.
All right. Thank you, Mr. Chetty.
Could I ask, are the windows in the balcony still in question?
What's the board's pleasure as far as addressing these issues?
Quickly.
I understand, but there are also questions that I would still like to ask of city officials regarding the roof. And so.
Oh, all right, go on.
Okay.
I'll just
Yeah,
answer
you
your
may.
question.
You may.
Everything's in non-compliance still. So.
Everything is,
Everything,
so we're just talking
Everything's in
about
non-compliance according
one of
to
the three issues.
Windows haven't been done. Balconies haven't
opinion
been
of
started.
the
No
city.
permits been pulled on them.
So
and,
I don't quite understand what the intention is to restore this building?
Well,
Is that-
if I may, my initial goal here today was going to suggest, since there is a pending demolition order, I understood at my last appearance before this board that I was to come to the April meeting to update as to settlement negotiations with
No,
the
that
insurance
was
carrier.
I think that at the last meeting, which was the March meeting, there was supposed to have been a progress report.
Yes.
And you sent it to
Mr. Clegg.
To Mr. Clegg. And was there any progress at that time?
So my understanding was when I attended the February meeting,
Yes.
I was, for purposes of the March meeting, was to provide an update to Mr. Clegg, which he would report to the board because I had a conflict on that day. And admittedly, settlement negotiations with insurance carriers on this scope of and extent of damage do not occur over a period of 30 days. So my understanding was I was supposed to provide an update to Mr. Clegg. He would report to the board, and I would appear for the April meeting, which I am here today. Now, with that said, we were very close to resolving the issues with the insurance
I
carrier.
think I recall that you said within 15 days you were going to have a meeting with the insurance
Right.
company.
And
did you have that meeting?
Well, we were having settlement negotiations.
Settlement negotiations, okay.
Okay. Ms. Kundig, I'm being only candid with
I
you,
know.
and I am being only honest with
Thank
you.
you.
It may not be enough for you, but I am only being honest with you, and we are only human, okay? We are trying our best to resolve the issues with the insurance carrier, okay? These are not easy issues. They are not resolved overnight. We were very close to having a resolution of these matters. However, we had to suspend those negotiations because a demolition order was issued on this property on Friday. Now, if I'm doing my duty to my client, I must suspend the settlement negotiations, even though we were a hair apart, because now the scope of potential damages to this property has increased dramatically. The city has gone from requiring this property to be fixed to being torn down and rebuilt up from the ground. And so with that threat over us, we had to suspend settlement negotiations with the insurance carrier because now we don't know if our damages are X or if they're Y. And I'm trying to set a meeting with the building official to determine the exact extent of renovations that are going to be required by the city, but we simply do not have enough time. I had a meeting scheduled with Mr. Clegg at the property for Friday at 1:30. that meeting was canceled because of the pending demolition order. So now, in a sense, our hands are tied because we have the threat of a $1,000 a day fine from this code enforcement board. In the meantime, we have the building department saying, thou must tear down this building. And so we have fines on the one hand, we have a building department saying, tear down your building. And on the other hand, I have an insurance carrier that I was literally a cat's hair away from settling the case with to get this property restored.
I guess it depends on your definition of cat's hair, huh?
Well, I'm not here to make snarky comments
Okay.
or
I'm sorry.
remarks.
This is a serious
issue, and it should be addressed seriously. I'm not here to make offhand comments. I'm not here to disparage anybody. I'm here to tell the truth, and I'm here to advocate for my client.
Okay,
And
I
so,
get that.
and obviously, you are upset, Madam Chair. But I will.
I think the board and the entire city is upset.
Certainly.
And I want you to understand why we're upset so it doesn't appear snarky.
I'm simply telling you where we are.
The intentions, we can't determine the intentions of anyone here. We can only look at what's been done and what hasn't been done. And the fact that there are people going in there and starting fires and that pool is open, the whole place is not secure.
I'll object to your testimony and your characterization. The property actually has a 6-foot fence around the property that the homeless are, in fact, breaking down that fence, and we are constantly repairing that fence. The windows have constantly been boarded up. Those boards have been constantly removed, and additional windows have been broken. So I'm not telling this board that I don't want to work with this board. I'm not telling this board that there aren't issues at that property. There certainly are. What I'm telling this board is please have some compassion. Please do not disparage a property owner that has been working hard with fighting with an insurance carrier, and now on top of it, we're fighting with a code enforcement board that we want to work with, and we're fighting with a building official who clearly we want to work with. We want to strike a balance. Offhand comments don't get us there.
Okay.
Could
you sum up in a couple minutes
this is what I will say. If we are reviewing the actual notice against this property, Vishnu has been cited for exterior conditions, roof, and drainage. You have testimony in front of you that R&R dried this roof in, and the city inspected that dry-in as of July 31st. There has been not one bit of testimony from the city that subsequent to July 31st, any representative of the city of Daytona Beach went on the roof of this property and identified any failures in that roof membrane. You have not heard any testimony that there has been any observation within the property that water is getting within the wall cavities or within those rooms. Now, you are literally citing for roof and flashing will be sound tight and not have defects that emit rain. That is the violation. The violation is not that a permit was pulled and a final was not obtained. The law is a technical thing. I'm not trying to get by on a technicality here. We understand that there are issues. But if the city is not going to work with us, candidly, I have to point out the defects in the pleading, in the notice. And that is your defect. You admittedly have, on July 31st, the city inspecting for a dry-in. It's approved on a dry-in. And now we have a violation saying that it's not dried in. You would need to have somebody go on that roof and find a defect to cite them under this provision. As far as window, skylight, and door frame, to the extent a homeless person broke a door, broke a window, those were continually remediated from the date of Hurricane Matthew to the present time. Admittedly, more doors are being broken into, more windows are being broken into. I have the property owner who can testify to that. But what this citation is, this citation cannot cite for things going forward. Meaning, if the door to room 101 is broken, this citation can cite that. If that door to room 101 is broken and then someone breaks the door to room 102, it can't be addressed by this citation.
If there's a condemnation on the property and it's to be torn down within 30 days, all of this stuff disappears. Is that what the intentions of
Absolutely not.
Vishnu's?
Absolutely not.
Their intention is to try to restore this property?
The intention is to appeal that order, to secure an engineer, to work with the city of Daytona Beach. And again, please don't misconstrue my tone. Please don't misconstrue my tearing into the sufficiency of this
Well,
notice.
it's not
we,
about you.
We,
It's
we
about
want
them.
we want to work with the city. We are asking for a reprieve. You must understand. At this point, and I said this the first time I appeared before this board, I am fighting with an insurance company, a code enforcement board, and now a building department. I don't want to fight with everybody. I want to work with and craft a resolution.
But you understand why. I mean, just looking at those pictures, which you have objected to.
Well,
But
I objected
the
because
pictures
they
on the
aren't
outside.
from. I object because they are subsequent to the violation date, so they're not relevant.
The pool issue is relevant.
And nobody could have actually accessed that pool because of the 6-foot chain link fence. So as a matter of due process, the code enforcement officer could not have made it to that point to photograph the pool because access to the property is blocked. Again, I'm not trying to be hyper-technical with the law. That's not my intent here. I want to work with this board. But if I'm going to...
What in your mind, working with the board mean?
My intention here today was to at least present Eric's testimony that this roof was dried in. So the board could have some understanding that this isn't a property where no efforts have been made. Because that's what I heard, was that nothing has been done since Hurricane Matthew, when in fact we dried it in. That is typical and customary in my business where an insurance company fights, you put a temp roof on there to mitigate your damages and try to preserve the property best you can. A temp roof was put on the property. A 6-foot security fence was put around the property by AAA Fence. At this point, we also have off-duty police officers at the property from 10 p.m. until 6 a.m. So we have them there at night to secure the property, to take care of the trespassing issues. We are in the process of boarding up additional broken windows. We've discussed I've discussed it with Mr. Clegg. I was going to address it with the building official, whether it would be prudent to just plywood over the entire first floor of the property. And we're doing our best to secure the property to address these issues. We are going to appeal the demolition order. We do not feel as though the building needs to be demolished. Of course, my opinion will defer to a structural engineer. That's what is required. And I think Mr. Urquhart will agree with me that ultimately he will look to see what a structural engineer will propose for the rehabilitation of the structure, if in fact it can be salvaged.
Okay, thank you. Mr. Jackson.
And so my proposal is this. Allow us to have a meeting with the building official and to come up with a plan to secure the property, to free the property of vagrants, to clean it up aesthetically from the outside as best as possible. Defer any fine, bring us back again next month, and at that time, if additional progress has not been made, then at that point we can discuss a fine. But in all candor, ideally, I would not object to a monthly status report, but as far as fines, that's not helping the problem. We're already in an impossible position, mostly because you can't put a roof on your house if you don't have money. It's no different if it's a house or a hotel. If you don't have the money, you don't have the money. And so I think if this story came out in the news journal that it was a home as opposed to a hotel, if you read a story in a news journal about a family losing their home and that their home would have to be demolished because their insurance company didn't pay for a roof subsequent to a catastrophe, I think everybody would be sympathetic. But you put it in the context of a hotel and it's a business and there's not a person behind it that is visible, and it's tear down.
Well, I beg to differ with you. This board is very conscious of the dilemma that this family are in with this hotel, and our request for them to secure it. Obviously, they weren't able to do that, or it wouldn't have been breached. We want to help everyone that comes here, and we give them a lot of opportunities to bring it up to code or to do the simple things that are asked of them. And making this pool in the building safe so it's not a public hazard has not been done effectively. I believe there were attempts. I understand the dilemma that they're in with the insurance company. That's unexcusable. But we can only deal with what we see and what everybody else sees when they walk by that building. And no matter how much you ask for an extension, if, it's already been extended over a year, and the things that were asked for originally still are not secure.
And Ms. Howard, I appreciate the sympathy. It's, that goes a long way for the property owner to understand the situation that they're in. What I'll say is this. My charge from the last time when I was here was to come back before this board and advise that the settlement had been reached with the insurance carrier. And whether I used
the last month.
February.
Yeah.
And we were within inches, if we don't like within
Okay,
a cat's
well,
hair,
yeah.
we were within inches of settling. It effectively would have settled, but for a demolition order being put on the property, because now that potentially increases the damages. So the settlement negotiations aren't completely off the table, but they certainly have stopped pending a more thorough understanding of what it's going to take to get this property back to its pre-loss condition per the building official.
And
so,
with
which is understandable. I'm not faulting him for doing his job.
It could
but
go on
understand-
forever, though. That's the way it's been with a lot of these insurance companies. And
I respectfully
the problems that are there are still there, and they haven't been addressed. The only options we have are to fine if they're not, the compliance is not met.
And I would remind this board that the goal is exactly what you said, compliance. The goal isn't fines.
One of the things that that's come up here, and if your clients would have taken precaution from the very beginning to secure the area, over the months we've talked about cleaning up the area. They took no responsibility of that and didn't do anything. They didn't secure it so where it was able for somebody to breach the building. They've got security after the fact. The change is you didn't have the building secure. That enabled somebody to either break in or to go in and to start a fire. That's changed the scope of it. Although that this isn't what's on the agenda for today, it's a fact that clients haven't been responsible on the building. They haven't been responsible to the city of Daytona Beach.
And
that's what they've not done.
And with all due respect, there is a 6-foot chain link fence around the property, and all the openings have been secured. So I don't want to muddy the waters or the transcript here. What really happened was in the middle of the night, somebody cut the fence, breached the fence, broke into the room either by breaking a door or a window. In this instance, it was actually getting a crowbar and prying open the door. So to the extent that the property was not secure, it's not secure just as any home in Daytona Beach is not secure, in that somebody can walk up to a property, break the fence or jump the fence, break a window and break into the property. And so that's really what we're looking at here. And if the board, I know the board wants to wrap up the testimony, I can't have the property owner testify that the windows were constantly boarded, and it's a constant cat and mouse game with this property that one window would be broken, one part of the fence would be breached, they repair it, and the next day something else would happen, or a week later something else would happen. And so it's a not to use a boardwalk term, but it's a whack-a-mole. One day room 101's broken into, the next day room 105 is broken into. And so to remedy that, we have hired off-duty police.
Don't you think that would have been
And that would seem to be the only way to stop this problem, because obviously we can't build Fort Knox there.
But it is your obligation to make sure it's secure in whatever means available.
Agreed, but our obligation isn't to make the property burglar-proof. And just like your home at home, it's not burglar-proof. Somebody could break into your home at any moment.
No,
All right,
your obligation is to make it safe for the public. That's your obligation, and obviously you have it.
And my suggestion to this board is we hear you loud and clear. There's nothing more clear than the building department's demolition order. We would ask that if a fine is considered, my suggestion and the way I've done this in the past is if certain remedial action is not taken within a prescribed amount of time, say 6 months, then a fine would be imposed. And I would ask to table this matter pending discussion between myself, Mr. Clegg, building official, and the city attorney, and so we can craft an agreed order for this board's consideration, which does the best. And
Okay, excuse me, but we have spent almost 45 minutes on this one case, and I would like to know what our options are, Mr. Jackson. My understanding is we're here to impose a fine for the 3 violations that still exist. Is that correct?
You're here to impose a fine on a case that has not been remedied.
Correct.
So the violations still exist. Madam Chair, I feel somewhat disadvantaged in not being able to answer a lot of the things that were said. I mean, this is a record being built. I have a chief building official who can testify that he's gone to this property and that he's interacted with individuals on this property who say they're living on the 4th floor. He has observations that were consistent with that this is a constant stay on the property by vagrants, trespassers, whatever he wants to define them. It's clear that in January, on record, it was recommended that they make this property a trespass arrest site. That was never done. The notation that it's now a duty officer on, that was just done last week or within a matter of a few days. That's not something that had been done, and it was available to him ever since this has come up. At the own admission of the attorney himself, this has been since Hurricane Matthew. This has come up by this staff, giving them almost a year until April for us to have the first contact to ask for compliance. And from April until today, there's been minimal done or to reach satisfaction of safety and well-being. The property in June is when they had pulled permits to start a roof. In July, they had a first dry-in on inspection, and since July, there's been nothing that brought our inspectors out. The position of the staff is that there's a need for this to get remedied, and it's not. I would ask, just because I want on record for Mr. Earhart to come on over here and to give you advise you as to what he believes would be the minimal amount of time to accomplish compliance, which I believe, from my conversation with him, compliance, the easiest compliance and most immediate compliance is demolition, and it can be done in 30 days. But I'll ask Mr. Earhart to...
Okay, Mr. Urquhart, please come forward. I want to make sure everybody... Mr. Klieg, are you going to want to say anything after Mr. Urquhart?
I don't believe so.
Okay.
I would ask one thing. I still haven't heard the condition of the balconies. Are they falling down, or what is that violation?
Well, you still have, they're still falling down, as well as a lot of structural cracking going in on the supports, especially in your lobby section. The cracks are vertical from the supports all the way up to the 2nd floor. I want to make it kind of clear, when we come in is when public safety has been breached. And we were confronted several times on the property just by tourists stating to us that they're being harassed and confronted by the homeless. And there's 3 buildings to the south that have just been remedied, and they've done a great job. And so you got the tourists coming in, but then they're being harassed by the homeless. So we came out and we followed after the fire department and the police department, which was last week. They had the 2 fires, and they also made a couple of arrests because they had plenty of people throughout the building. As they're going up the stairs, they're scurrying about. Now, we followed that up 2 days later and went ahead and posted it. And while we were there, we were confronted by the homeless, and they said, all right, well, we're leaving out of here. I was staying up on the 4th floor with everybody else. So they're staying up there. They're using the linens. So at that point, it becomes public safety situation to the tourists that are visiting here in Daytona Beach. As far as the demolition, we cite them, and the process is they get 20 days to appeal. He said he's going to appeal. I'll meet with him, and we can go over the process of what they could do to rectify it, just like they went over the process over a year ago, and of course there has been not a lot of progress. So in moving forward, we'll deal with the appeal. We'll see what they want to do with the structural engineer. Then that process will follow that route in the same way.
Okay, thank you.
But
You're
the
welcome.
question is, as far as being able to remedy this situation by demolition, if that's what was done, what's the minimum amount of time with diligent effort and
A demolition company could take it down without the recycle process. They could take it down in 30 days. Some could take as long as 4 to 6 months, because then they'll recycle all the concrete and all the steel out of it. One additional thing that I did not say was, as far as the pool, you can see the pool from the side. You don't have to step onto the property to see it. It's got a 3 to 4 foot gap running the whole length of the pool, and you got people that are actually living underneath the pool. You know, the homeless people. So it's where all the sand has been undermined and out. There was one, as I stepped over, it was sleeping down there with the comforter in their box of cereal. So when it gets to this point, that's when us as a city, we have to
Absolutely,
step
the
in.
safety of not just the tourist, but also of the homeless person himself and the rest of the citizens that walk by. It really is a huge public safety issue. So, Mr. Jackson, what I would like to know is, we are here, and the violation is failure to maintain roof, windows, and
If I
that.
may take it, I'm not allowed to cross-examine the building official.
Yes.
First of all, we're going on our tangents. We've already found this in non-compliance.
Right.
What we're doing today, we're rehearing the case now. The issue is whether or not it has been done, things done since the last date, to pay the compliance or not. They said they're not, he has an opportunity if he wants to cross-examine them, said they do. And that's the issue for us today. Are they in non-compliance or not? If they're not in non-compliance, we want to give them more time, we want them to sue the fine. That's the issue. So we've already
Right.
decided that. But it has to be on the issues of the roof, the windows, and the bottom.
Correct.
Nothing else. The pool is not in front of us today.
Right.
Well, and that would, those were my questions, because if I understand it correctly, the building official never stepped foot on this property until recently, and so any testimony that he has lacks any foundation or knowledge that is applicable to the notice and the issues that are presented. And he also testified that there's cracks and the stairways, decks, and porches and balconies are falling down, and so I would respectfully submit to this board that they are not in fact falling down. That Mr. Harrington himself said it when he said, I'm not aware what, we haven't been presented anything. Mr. Harrington himself, his statement belies the fact that this property is out of compliance relative to the balconies, or at least supports the notion that insufficient evidence has been presented to this board that there's a lack of compliance. The way it should read is, the way this notice should read is, the balcony for room X is damaged. The window for room Y is damaged, and then we remedy those. What has happened here...
At some point, do I get a chance to talk,
Yes,
Madam Chair?
I want to be clear. What has happened
Excuse
here
me, I want this to stop now.
Well, may I justify one thing? Because I don't know doesn't speak for the whole board, so don't use me as an excuse for what I said.
Well,
I'm going to ask
my
our board-
apologies, Mr. Harrington, for singling that out, but it's exactly what I'm trying to point.
I want order now. This has been going on for close to an hour. We are here to we have already found the building in non-compliance. We are here to either give this company more time or to fine them. That's it. That is the scope of what we're doing. Is that right?
That's correct. For enough evidence, just make it.
I've heard enough, I think the whole board and the whole city at this point has heard enough evidence of what's going on. here.
I move the
Madam Chair, if I
question.
can just clarify one thing. now.
One thing.
And this, I differ a little bit with Mr. Sino in that what we need to hear in terms of evidence is evidence that supports your fine, if indeed you're going to find that they are in violation and that that they meet the criteria that's in statute as well as in our code, which is looking at the efforts that they've made to come into compliance, which is what we've been talking about, which includes the orders that you've given from the bench in terms of actions to be taken, the egregiousness of the violation, and the general history and status of the violator. So those are the things that you're considering as we talk about this case. And the status right now, as far as what's going on with the condemnation, that's a whole different line. That's a parallel. That's not the same as what's happening in code. The code board action goes forward on its own. What happens with the condemnation goes separate on its own. The recommendation of the city as it relates to the code action is that it's been enough time. January was when you gave the first order for compliance. You asked for a report last month. The compliance date was for this month, and it's not in compliance. And the efforts to come into compliance expressed by council is delayed by all of these other things about insurance. We've heard all of those before. We've considered those issues in the past. But where we are today is that because of the issues of health, safety, and welfare, the city's position is a $1,000 fine should be imposed to a maximum of $45,000.
Okay. Let's do it. Any more comments from the board? The chair will entertain a motion to impose a fine of $1,000 per day against the respondent, effective today, April 12th, 2018, and continue until compliance is achieved or reaches the maximum of $45,000. Is there such a motion?
So moved.
Motion, Mrs. House. Is there a second?
Second.
Second, Mr. Jones. All in favor say aye.
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 Like sign opposed. Roll call vote. All right.
Mr. Weatherholt?
Yes.
Ms. Purdy?
Yes.
Mr. Jones?
Yes.
Mr. Harrington?
Yes.
Ms. House?
Yes.
Ms. Himes is absent. Ms. Hunter?
Yes.
That is 7 to 4.
All right. Thank you. This case is done for the day.
Fixing order.
Six.
Does that count?
I'm going to take a break.
Yeah, the vote was 6-0. Because Mrs. Himes is not here. All right, we're going to go back to lien review 1, CEB 0504-102 at 349 Fulton Street. Rosalie Akins, care of Isaac Akins, and the new owner is Anthony Rangasamy.
Good morning. How y'all doing?
Good morning.
Anthony Rangasamy. My home address, 145 Diane Drive, Ormond, 32176.
Do you solemnly swear or affirm that the testimonies that you're about to provide is the truth, the whole truth, and nothing but the truth?
Absolutely.
Okay. We're going to just hear a short review for the history of this case. This is total amount that's owed is $1,328.89 is the remainder of the lien.
Yes, Madam Chair, members of the board, as you can see, actually, lien review number 1 and lien review number 2, it's the same property owner, the basic same owner, different properties. The basic situation isn't it different properties? Oh, I'm sorry, same property, same owner, same property.
Different properties. Mm-hmm.
But 2 cases. And the circumstances is that was purchase tax deed, right? And so as part of this tax deed process, there were excess proceeds that the lien accrued to $15,014 when we include the recording fee on lien review 1. And then on lien review 2, it accrued to $15. So it maximized them both. The violations for on lien 1 was in 2004. Lien 2 was in 2007. So these are two properties that are set in noncompliance with liens accruing for over a decade. As I said, the current requester for lien review now owns these properties. They have been renovated, improved. The inspector reports that they're in compliance and are by appearance nice properties. The request from the city is on lien review 1 that a fine of $500 be imposed. On lien review 2, a fine of $1,000. So for the two lien reviews, a total of $1,500. I'm sorry, reduced. I said imposed.
Right.
That'd be reduced to $500 on the one, which is and $1,000 on the second.
So we have two different houses, or
No,
just two
I
different?
said
It's
that
one house.
One house, two different orders
Two different orders.
from two different periods. One from 2004, the other from 2007.
Okay. Yeah. Okay. The other case, which I didn't, are we considering these together or separately? All right. The second case that we're considering the lien review is case number SMG 0207-43. So we're going to combine these.
Yes, all in all, it's really
Or do two
all on
motions.
one property in terms of what the obligation was, and the recommendation is taking the whole picture, which is, if we took it as a whole, it would be $16,328, and reducing that to the sum of $1,500. It's approximately about a 10% reduction to 10%.
Okay. Do I have comments from the board before we go any further with this?
Yes.
Go ahead.
When you bought the property, you paid the tax bill,
Yes, sir. I bought it for $22,000.
$22,000. You paid absolutely nothing against the liens directly?
There was excess proceeds from the tax sale, which
How much?
It was $18,000 altogether. $5,000 of the $18,000 went to utility liens, and there was a excess of $13,000.
And that went to the tax lien?
That's to the city right now, who's asking.
But not for, that went for the back taxes.
Back taxes were already paid.
Okay, they were-
$18,000 was the leftover out of the $22,000 paid to the tax lien.
Okay, so there was
$18,000.
only
So they
about-
kept their own,
Okay.
whatever it was, and then the rest came to y'all. Yes, sir.
And just for a clear number, that was $13,671.11 was the excess proceeds that the city was able to receive against the lien. That's why the only amount on lien review 1 is the $1,328.
Yeah, the other $5,000 I was talking about went to utility liens. That's why I was saying $18,000.
Okay.
I mean, I've printed pictures up and all that. I've dealt
We can
with.
see those pictures. The house looks nice.
Oh,
When did
no,
you
No,
purchase?
these are my own. That's just the front. If you guys want to see them, it's the inside and stuff like that.
Thank you. When did you purchase this property?
I purchased it right before Christmas of 2017.
Okay.
And within a month, I had all my violations,
And-
safety concerns fixed.
Okay. Well, thank you for
You
fixing
were
it up.
aware of the liens at that time? They were,
Yeah, you know what? I looked at it, sir, but I didn't realize it was that much of an extent of the penalties. You know what I mean? That I seen, because what I seen on the public records, that buyer beware type deal, it didn't look that much to me. So I misread it. It was my fault, to be honest with you. But all I'm asking for here today, I'm not going to even, after what we just went through for an hour, I'm not going to bore you with my statement here. Basically, me and my wife here today, who took the morning off, we spent pretty much everything we had, fixing the house to where it is. Two separate things, so y'all can, if you want to look at it.
No,
but
I
I mean,
we-
it's up to
there's-
date.
yeah.
It's up to date. It's brand
Yeah.
new, basically.
Yeah. Great.
You know, I got quite a few properties, and I've dealt with quite a few of these codes enforcement officers, Mr. Stinson and a couple other ones. I fix my stuff like that. You know, I spend my own cash, don't wait on insurance. I just do it. They pay me back. You know, I like people to live like I do.
What is your intent with these properties? Do you plan on selling them or renting them?
Well, we actually plan on renting it, to be honest with you. You know, I just don't know at this point. But I just have a question for this gentleman. So reducing it to 1,500 or whatever, would that, with what you have in the XCs of 13,000, would that satisfy everything?
No, that would be over and above whatever we've already received. So we're asking for $1,500 to be paid. That's what our request is.
So $1,500 besides the 13,000 you already
Yes.
got? Yes. Okay. Well, what I was asking for was just to take the 13,000 and just satisfy it all out. I mean, that's basically what I was asking, because we pretty much financially exhausted behind this property. So to answer Mrs. House's question, we'd love to keep the house, you know, as a rental or something like that, and keep it up to date, safety.
Do you have other rentals?
Yes, ma'am, we do.
How many?
We have 3 altogether, but I do property management in town. And like I said, I've dealt with other faces here, and they're all up to date. I have 15 other ones that I manage myself. So I'd like to keep it under my jurisdiction.
It looks great, and the inside looks good.
I keep them all like that.
You did a nice job. Thank you.
Yeah, but this one I
Thank
can't
you
do it
for
with any
fixing
other
the
penalties or
property.
anything like that. I'm just exhausted financially behind it.
Okay, any other comments from the board? All right, the chair is going to, let's do lien review number 1, CEB 0504-102. The chair will entertain a motion to reduce the amount of the lien to $500, subject to being paid within 30 days, or the fine will revert to the original amount. Is there such a motion?
Bill, on that second. Tony, you've already gotten 13,000, so we're not reducing the lien to $500.
Say that again. I'm sorry?
You've already gotten $13,000 on this lien.
Right.
So we're only reducing it to $500, because if we reduce it to $500, $13,000 have to be refunded.
Well, actually, no. Yes, we've gotten the 13,000, but the original lien amount was 15,000. So it's a remainder of 1,300 that's remaining.
Reducing the lien to 13 plus $500.
No.
No. We're reducing the lien to 500, the remainder of the lien.
We already got 13,000.
I believe what the requester, and he can nod or shake, but I believe what the requester was requesting is that if we looked at this as a whole, which would make it a $30,000 between the two, that we take the 13,000 and let that satisfy everything. So basically a waiver of whatever's remaining.
To go down to zero.
Yeah, he's asking to waive everything remaining. We're asking 500 on the first and 1,000 on the second.
So is that clear to everyone? All right. Is there?
Excuse me.
Go ahead.
Oh, I just have one more quick thing to say before you guys. None of these were my liens. This is something that we just walked into. So just please keep that in mind.
Mr. Jackson, is there a way for somebody who's not a legal expert, or that you could phrase these things so it would be a little easier to understand when you have Mr. Sino asking questions and you're asking questions? Because the language be a little clearer next time we have one of these? That's all I'm asking for.
Certainly, Mr. Harrington.
I mean,
I'm just concerned about the motion because reducing the lien to $500, we've already gotten 13,000 on this part.
So we're reducing the remainder of the lien.
Yeah, I understand.
Okay. I'm going to amend my own motion, or amend what I'm going to ask for a motion. The chair will entertain a motion to reduce the amount of the remainder of the lien to $500, subject to being paid within 30 days, or the fine will revert to the original amount. Is there such a motion? Motion, Mr. Harrington. Second, Ms. Purdy. All in favor say aye. Aye. Like sign opposed. Motion carries. In case number SMG 020743, the chair will entertain a motion to reduce the amount of the remainder of the lien to $1,000, subject to being paid within 30 days, or the fine will revert to the original amount. Is there such a motion?
I would like to see the same amount paid on this one as the prior one. I feel that this is one that's going to be a big loss to the city, and I feel like that the first one was $13,000 with an additional $5,000, and this
No.
one should be as well.
The first one was 15.
Amend her motion to make it $500. You need to be a second and then vote on the amendment and then make a motion.
We haven't made a motion yet. I just said I'd entertain.
She would have to do- she must-
Yeah. Well, would you like to make a motion?
I make a motion that we propose a fine of $13,000.
Reduce the, you want to reduce the lien to $13,000.
Yes.
Okay. Is there all right, there's a motion from Mrs. House. Is there a second? Motion fails for lack of a second. Someone else? I mean, it's my opinion that at this point, I know the city has understandably lost money on this. We have gotten some money back, and it's close to, I don't know, close to half of what was owed. Would anybody else like to talk about the amount?
What is your recommendation?
1,000.
Well, his recommendation's 1,000. No.
The recommendation of staff was $1,000 on the second case, basically making it a total of $1,500, which
Right.
would have been 10% of the amount of the second case. It really, I mean, it was really the same effect of saying
Which covers
waiving the
administrative
first and
costs and
10% of the
everything
second.
else.
And that's looking at the work and efforts that's been done by this respondent and the now improved condition, and the fact that this this requester had nothing to do with the initial violations or the status of it sitting for the many years that it sat.
I have a quick question. I think I'm a little bit confused. So basically, what you're saying is I would still have to pay another $1,500 plus another $500, so $2,000 out of pocket.
No, $1,500 total out of pocket.
Okay, so that would still come out of
At
pocket.
this point.
Yeah, that's what
Wow. Okay.
I think the amount of $1,000 the city's requesting is a little low.
Okay. Well, what would you suggest?
I would recommend $5,000.
Would you like to put that in form of a motion?
I'll make the motion to on this one here at $5,000.
To reduce the amount of the lien to $5,000.
to $5,000.
Okay. We have a motion from Mr. Weatherholtz. Is there a second?
I'll second that.
Second, Ms. Purdy. All in favor, say aye. Roll call, please.
Mr. Weatherholt?
Yes.
Ms. Purdy? Yes. Mr. Jennings?
No.
Mr. Harrington?
Yes.
Ms. House?
No.
Ms. Cundiff?
Yes.
1, 2, 3, 4, 2.
Okay, 4-2. Motion passes. Okay. Okay.
It's new.
All right, yes. The board passed a motion to reduce the remainder of the lien on the first case to $500 and to reduce the lien from $15,000 to $5,000 in the second case.
Okay, so what
So
is that
it'll be
exactly?
total left of $5,500 owed to the city on the lien.
So I would still have to owe that out of
Yes,
pocket,
yes.
even though I came forward and corrected all the violations
Yes.
in favor for this, and
Yes.
Mr. Weatherholt pretty much decided to fine me another $5,000.
Mm-hmm.
So what I'll do is won't pay y'all a damn dime and keep the property in my own pocket.
Knock it off.
Okay. All right. All right, we're going to start case number 1. CEB 11-17-142, Nell 4 LLC at 713 Cedar Street. Respondent present.
Yes.
Please state your name and address for the record.
Ben Spivey, 10537 down
What,
Lakeview
I'm sorry,
Circle.
what is your name, sir?
Ben Spivey,
Ben Spivey.
10537 down Lakeview Circle, Windermere, Florida.
Do you solemnly swear or affirm the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
What is your relation to Nell 4?
I own the company that owns
Okay.
Nell 4.
Okay, thank you. All right, Mr. McCoy and Mr. Jackson, do you want to go over this and tell us what's been done?
Yes, but if I can just get one clarification from Mr. Spivey, because I was asked to get clear on the current ownership of the property. Who currently owns the property?
The ownership's transferred to BMS Holdings. This is, which is the company that owns Nell 4. So currently it's owned by BMS Holdings. And I, Ben Spivey, own BMS Holdings. Okay, this has been going on for a while, so that's what the current ownership is.
So we would move to amend the respondent in the case and add BMS Holdings as a respondent. And I don't know if you have any objections. You can speak to that.
So we need to do that.
If I understand right, I believe Mr. Spivey has conveyed it.
Would we need to then recite? Is that going to, or we're just...
What's the property? Do you own the property now?
BMS Holdings owns the property.
Are you BMF holding?
Yes, Mr. Spivey.
Yes. So it's BMS Holdings, owned Nell 4.
But you're also BMF holding?
I'm the only single entity owner.
So it's all right, okay.
So one entity owns the other entity
Okay.
that owns
All
the
right,
property.
so we don't have to, all right, we're going to amend.
Just
then.
add the additional entity and ownership.
Okay. Okay.
Okay.
All right.
All right. Now, this property, I've also received, and I guess this, I don't know, I guess got it from Mr. Spivey, someone, that they had an order approving a joint stipulation where one of the things that was going on with this property, and I guess I got to back up a little, kind of got a little ahead of myself, Madam Chair, members of the board. This is before you for imposition of a fine. And there was a joint stipulation, as I was about to say, that I have a copy of that, where Nell 4 LLC and the tenants, this was an issue where they had a problem with tenants and needed an eviction. And so ultimately the remedy was they did this joint stipulation and the tenants were supposed to be out by, and the property was supposed to be back in the possession of Mr. Spivey by March 31st. And so with that understanding, the intent of the staff was, and the intent of the staff is still to ask that we amend to the next cutoff to allow Mr. Spivey the opportunity to bring the property into compliance. My understanding from Mr. Spivey, at least from my inspector, is that even though they have this joint stipulation, apparently it wasn't the action didn't take place as required, and there may be some other issues. But the position of staff right now is that this property be that this case be amended to the next cutoff, just to allow, now that he's regained possession of the property or was due to regain possession of the property, to allow him the time to comply with the order.
You're saying due to receive the property?
He was due to receive the property, and my knowledge coming in was that he received it based on the order, but I'm understanding that he will be testifying or at least expressing that he has not. So I don't know the details.
Is that stipulation legally enforceable?
Oh, yeah,
Is
this
that
was
a
signed
court
and
order?
approved. Yeah, this is signed and ordered by Judge Fields.
Oh, okay.
Yeah. And so he'll take whatever next actions are necessary on his, he'll have to make that decision.
Ben, would you, thank you. Mr. Spivey, let me ask you a question. So is the tenant in or out?
These pictures were taken yesterday, you said?
Yes.
Okay, so the property looks vacant. We have not been inside the property. As of now, when I was here in February, you gave us 2 months.
Right.
I mentioned to you that his lease was not up until June 30th.
Right.
We effectively negotiated terms with his attorney to try to get him to vacate the property 3 months early, which was March 31st, to
March
get this to move
31st,
along.
okay.
However, my attorney, John Morey, email this morning is that they have filed the motion not only for disbursement, but the package to the judge today. But as of today, the case is still open and active, and for me not to enter the property for our safety because it's had the pit bulls inside. So we expect that we'll have possession of the property probably in the next week. And as you can see the outside, we did clean up the outside.
Yes.
When they
Yeah.
left and vacated. When people leave and are evicted,
Right.
they don't leave it clean.
Right.
You can see we cleaned up the outside. We just have not gone inside. That's where some of the
Okay.
issues are. So the outside is clean. We're just looking for an extra month or two so we
Okay.
can get inside. We'll probably be in about 2 weeks.
Okay, cool. All right. Any other questions? The chair will entertain a motion to amend the previous order of noncompliance and allow the respondent until, that would be May 2nd, 2018, to come into compliance and be returned to a subsequent meeting for consideration of a fine of up to $1,000 per day until compliance is achieved. Is there such a motion?
So moved.
Motion, Mrs. House, second, Mr. Weatherholtz. All in favor say aye.
Aye.
Like sign opposed. Motion carries.
Have a good day.
Thank you. All right. Case number 2, CEB 12-17-167, Three Oaks Inn. Aha. Respondent is present. Good morning.
Edward Carney, 923 North Oleander, general contractor for the owner.
Okay.
Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do. And I brought pictures for a status update.
Okay.
I also brought
We
some-
are here for a progress report.
Yes, ma'am.
Okay.
I also have some further information for the board at this time. Mr. Urquhart had asked me to require or request a structural engineer for the property per the city. We had a structural engineer come from Cocoa Beach because there isn't one currently in Volusia County. So we've had a structural engineer, a true structural engineer, not a civil engineer, but a true structural. Yes, a real structural engineer at the request of the city. I've retained one, and Mr. Urquhart has copies of the paperwork. The building is structural. It is sound. They did ask us to replace 4 concrete, forgive me, 4 concrete bearing shore posts, and
Okay.
we've done that as well. So the building is structurally sound. We have the west side of the building and the south side of the building completely devoid of all the old lap siding. We have new plywood, new Tyvek, and new hardy board cement composite siding being improved as we speak. But through the dedication of the owner, this would never have been done any other way because it's a very costly expense.
So what is your relation to the owner?
I'm the builder.
Builder.
Yeah.
Okay. All right, Mr. Jackson and is Mr. Reckenzone here? Okay. Mr. Jackson.
Yes, Madam Chair, members of the board, as you said, no, this was here for progress report. I believe he gave you that report. I was looking to try and see what we had for a compliance date.
We don't have a compliance date yet.
Okay.
What? Well,
I
we
don't-
could set
are we in a-
one or just order another.
Please.
When do you feel it'll be in
Well, wait a minute, let him
compliance?
come up to answer that. How long do you think this project will take?
Every time we open every time we open the box up, we find something different,
Yeah.
and that was why we hired the structural engineer. Just getting a structural engineer to Daytona is 10 days to 12 days out, and those are business days. So the last time I was in front of this board was February, and it looks like we're going slow, but we've
Yeah.
had rain, we've had weather, and we've had relationships with the city that we fostered in order to get this done. So, meaning the structural engineer being hired
But we still need an idea. How long do you think it's going to take?
someday this year. I'm just being honest with you.
To impose something on a structure this size and the type, the gentleman's right about, every time you open up a wall,
Right.
something's different.
All right.
And remember, we're putting all new windows in this property as well,
Yeah.
with screens.
Well, any improvement is vastly going to be better than what it was. So I think that giving him a little leeway on the time of completion, having an
Well, we can
update, I think that we need an update, especially after the structural.
I'll gladly come back in 60 days, bring you more pictures.
Mr. Reckenzone, are you satisfied that there has been progress made?
Yes, ma'am.
Okay. So what is the city recommendation, Mr. Jackson?
Madam Chair, I was reminded that in your last order, we did actually order bi-monthly progress reports through August. Next week, he's scheduled to come back before the board in June 14th and then August 9th.
All right, fine.
And then maybe at that point, we can,
Okay,
somewhere
then we
along the
don't
line,
need
we'll
to.
be able to determine.
Okay, then we don't need to do anything more with that. All right, thank you.
Thank you.
All right, case number 3, CEB 01-18-17. Oh, yeah, the pictures. Do you want your pictures, sir?
Oh, no. Leave them.
JL&W property of Daytona at 1116 Madison Avenue. Good morning.
Good morning.
What is your name, please?
I'm Mary Lynn Hastings. I'm the property manager for this particular property. And, sure. Yes, I do.
Okay, we'll hear from Code and then the tenant. Okay, go ahead. Mr. Jackson.
Yes, Madam Chair, members of the board, this is before you for imposition of a fine. The inspector is John Stinson. Mr. Stinson reports that this property had a past issue of a tenant problem. The tenant was evicted on 3/5. They do have a number of things they still need to take care of, and it's recommended by the inspector that we amend to the next cutoff.
What things do they have to take care of?
And yeah, I'll tend to Mr. Stinson. He can explain any those factual information.
All right, so the tenant was evicted as of the 5th of March, is that right?
Yes, ma'am.
Okay. Okay. Go ahead. What would you like to tell us, Mr. Stinson? What needs to be done?
Good morning, John Stinson, Code Inspector. My qualifications are on file. As you said, the tenant has finally been evicted, and these pictures are from yesterday. They are wide open with the crew. I mean, they've already fixed the exterior. They still have some windows they need to take care of, but the interior is going to need quite a bit of work. The general contractor was on site yesterday, and he assured me that he'd be able to complete this within the next 30 days.
All the permits have been pulled?
Yes, sir.
Okay. All right. Any other questions? All right. The chair will entertain a motion to amend the previous order of non. Did you want to say anything?
I took this property on.
Well, come up here and speak into the mic, please.
I own Maryland Realty, and I manage over 200 properties in Daytona Beach.
Mm-hmm.
First time I've ever been before this board. I took this on in December from an owner that had been bought it with a tenant in place.
Yeah.
And
Yeah.
so
Okay.
it
We
will be
understand.
brought up to code.
We understand. Okay, thank you.
Okay.
The chair will entertain a motion to amend the previous order of non-compliance and allow the respondent until May 2nd, 2018 to come into compliance and be returned to a subsequent meeting for consideration of a fine of up to $1,000 per day until compliance is achieved. Is there such a motion?
Move.
Second.
Motion, Mr. Weatherholt, second. Mr. Harrington, all in favor say aye.
Aye.
Like sign opposed. Motion carries. All right. Case number 4 is in compliance. Case number 5 we heard. Case number 6.
Please don't be snarky.
CEB 02-18-19. Robbie and Wendy Burke at 273 Hartford. Respondent present? Okay. Come forward, please. State your name and address for the record. Are you Robbie?
Robbie Burke, 273 Hartford Avenue.
Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Okay, thank you. Let us hear from Mr. Klieg and Mr. Jackson first.
Madam Chair, members of the board, this is before you for imposition of a fine. Was for failure to maintain a roof. This is the primary violation. The inspector reports that the roof permit was issued on April 9th, and so it's not final at this point. So he's asking, the inspector's recommending that that this case be amended to the next cutoff. The inspector's Tom Klieg, and I tend to Mr. Klieg if you have any factual questions.
All right, Mr. Klieg, so we have permits that have been issued.
Yeah, permit's been issued.
Good.
I think the work's almost complete, if not because of the rain.
terrific.
Yes, thank you.
Yeah, no, yeah.
And it just needs to be final. There's no, I don't think there's going to be no issue with it. It'll look good.
Okay. Is the property occupied? No.
It's up
Okay.
for sale.
Okay. All right. Any other questions from the board? All right, the chair will entertain a motion to amend the previous order of noncompliance and allow respondent until May 2nd, 2018 to come into compliance and be returned to a subsequent meeting for consideration of a fine of up to $1,000 per day until compliance is achieved. Is there such a motion?
So moved.
Mr. Harrington, motion. Mrs. House, Ms. Purdy, second. All in favor say aye.
Aye.
Like sign opposed. Motion carries. All right, case 6 is in compliance. Oh, no, sorry. Case 7 is in compliance. Case 8, CEB 03-18-28. Melnick Lazenby Investments at 828 North Grandview. Is the respondent present? All right. First notified in November. All right. Well, Mr. Jackson.
Madam Chair, members of the board, this is before you for imposition of a fine. The inspector is Tom Klieg. Mr. Klieg reports that the issue here is the failure to obtain the rental license. They had an inspection. They failed the inspection on March 29th. And so there are minor things that need to be repaired, but they're not done yet. So the inspector's recommending that we amend to the next cutoff for them to complete what's necessary to obtain the rental license.
I'm looking at this violation, failure to obtain rental violation. Oh, no, this is failure to maintain, which one?
Number 8.
Okay, number 8. Sorry, I was getting my addresses confused here. What occupancy limitations? What does that mean? And then there's a dash in room area. I'm confused about what that means.
There was an intent to remove that off of the agenda and strike that. I think that was resolved, but it's not really something that required being heard.
But it is on here.
But it's remedied.
This is a
So
multi-unit.
could you explain that, though? I'm confused about what that means.
Yes, ma'am. What it is your room occupancy square footage, and it's supposed to be 70 square foot, and this room had 90. I remeasured wrong at the time, so that's why the good came into compliance for the room occupancy.
And what is still left to be done to get
I'm not
the
quite sure.
license?
Officer Jones did the inspection. He can I'm sure he can advise you what's left. I think it's minor.
This is a multi-unit building?
Yes, sir. It's 4 units.
4 units. Are they 1 or 2 bedrooms?
It's 2 bedrooms.
Does he have licenses for the other units, or are we just talking about?
No, this is for the whole property.
And he has no licenses?
He's got a license on file, but it failed the rental inspection, and Officer Jones can advise you what it was. It's like a smoke detectors or whatever, windows. But the whole, it's a 1 unit, 4 unit. It's a 4-unit apartment complex, and so they just need 1 RTL license.
Right, for all 4 units.
Right.
So the occupancy limitations have been taken
Yes,
care
ma'am.
of, and you mismeasured?
I mismeasured. The rooms look small, and I didn't have my tape measure with me, so I did it by
look
feet.
small.
My feet.
They look small for what? I mean,
Well, at the time of the violation, when I did the inspection, it looked small for a bedroom.
What is the actual date?
It's a minimal.
Yeah, it's a minimal square footage.
yeah, okay. And what is that?
70 square feet, and this was 90.
For the record, what is the actual date of first notified? It wasn't 11/30/2018.
Actual violation for the rental was first notification. I'm sorry, it was 11/30/17.
Okay, so it's a year now.
No, 6 months or less.
6 months.
I mean,
yeah.
6 months, yeah.
11/30/17,
Yes.
right? Okay.
Okay.
Are there any other comments about this? Yes, we will take testimony.
Do you want to hear Officer Jones what it needs
Yeah,
to do?
Mr. Jones. Yeah, right after,
Yeah.
let Mr. Jones just have a seat, please, Mr. Remark, and we'll have. Mr. Jones, what can you tell us?
Mark Jones, Neighborhood Services. We did do a rental inspection of the 4 units. Each one had some deficiencies, but they were very minor. A window that wouldn't stay up, one that didn't have screens, a smoke detector. So it was no. And they're given 30 days to correct that, and they'll call for a reinspection. So
Okay.
no other issues.
Okay. Mr. Remark.
State your name and address.
Tracy Remark, 815 North Oleander Avenue, and I also own 301 Riverview Boulevard.
Do you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do. Okay. First, I want to give testimony on this building because I think there are bigger issues here. And I'm intimately acquainted with this building in 2 ways. There was a gentleman that lived there. This is in the late 90s. He was homebound. He was in the downstairs front apartment. He had an Afghan. He needed help from neighbors taking care of his dog. I've been in this building along with the neighbors. These were 1-bedroom apartments, all 4 of them. They were 1 bedroom in the 90s. When I purchased with my family members the apartment building I own at 301 Riverview Boulevard, which is around the corner, this is one of the buildings that we actually looked at. It wasn't listed for sale in MLS, but you sort of know other multiple property owners. And we went in there, and those were 1-bedroom apartments.
And when was this?
This was, I was going to say, we bought our property at Riverview in 2011, so we were there the end of 2010, the beginning of 2011.
Okay.
All 4 of these units were 1-bedroom apartments in the 90s and in 2011. The reason both those dates are so important, I'll get to that in a minute, but the new owners apparently, when the inspector originally went in there, when it was called in as a code complaint for construction materials going in and doors and things like that, was told by the new owners who bought it, I believe it was last December, or December 16, I have it somewhere, and you'll see that in a minute, but was told that they bought it as 2-bedroom apartments, which means Mr. Bryant, that owned it before and has owned it since 2000, would have had at some point illegally had to have put in those 2nd bedrooms. And that some point would have had to happen between 2011 when I was there and when they bought it, which was last December. So I find that actually I have a hard time believing that, but additionally I have a hard time believing that because I'd like to pass this out to you guys if I could. There's 5 of them, so share. This is testimony on other...
Wait.
What is this?
It's some of what I'm showing that shows these are 1-bedroom apartments.
Okay, but that's not in front of us today.
I know, but what's in...
Staff?
Okay, what's in front of you, I don't think you can... What I'm saying is I don't believe that you can confirm a rental license on a property that is non-conforming, that it expanded a non-conforming use.
But that's not an issue for this board.
Okay, so how do we deal with this? Because...
To present the staff, they'll investigate it.
Okay, so this is...
What it would be like this board institute their own violations. You can't do that.
Okay, so...
Because they come back to us later as a case. So you, with staff, tell me, believe that there's a violation by
Okay.
converting one bedroom to 2 bedrooms. And they'll go, if there is, then they'll bring a case in front of us.
Okay, so does that mean, because I just wanted to make sure, since they're not, since they don't meet the rental license, that does mean, so I'm very clear on this, that this board today cannot find them in compliance for that, correct?
They're not in compliance today.
Okay,
It's
so,
been
and you can't
testified
find,
to.
okay, so
Right.
this has to come back to you for that.
If they bring it back to us.
Right. So I would meet with them.
Right.
Yes.
Okay, do I meet with legal?
No.
Who do I meet with?
We can't tell you.
Okay. Oh, I meet with Mr. Cligg? Okay, thank you.
That's a start.
Okay, because I started with development services.
No, we understand.
Okay,
Yeah, it would be like if you brought something to us, we would be interested in a case. Well, the statute doesn't allow us to do that.
okay,
But once they get some information, there is a case, they'll bring it to us.
okay, all right, thank you.
So what we're ruling on today
So I'm
is
done
that,
here, right?
Yeah.
Okay.
Thank you very
I
much.
wanted to be sure.
Failure to obtain a rental license. That's it. The other two things are not an issue. All the,
So they're saying they need this. Just 30 days. The stuff that they have.
additional 30 days.
Yes, that's correct. That's position of the
And-
staff that we need to amend to the next cutoff.
This other issue.
Yeah. Okay. So we're just going to amend this. Yeah. Is that? The chair will entertain a motion to amend the previous order of noncompliance and allow the respondent until May 2nd, 2018 to come into compliance and return to a subsequent meeting for consideration of a fine of up to $1,000 per day until compliance is achieved. Is there such a motion?
So moved.
Second.
Motion, Mr. Harrington, second, Mr. Jones. All in favor say aye.
Aye.
Like sign opposed. Motion carries. Okay. Case number 8. C9, sorry, I'm getting my numbers confused here. Case number 9, CEB 11-17-158, AF 126, at 126 South Oleander. Respondent present? I think someone showed up before. Mr. Rice or Mr. Bretzel, are either of them here? Mr. Rice? Are you Mr. Rice? Mr. Bretzel here? So nobody's here. Okay. No one's here. So we need to hear from Mr. Jackson and then Mr. Jones.
Yeah. Madam Chair, just again for just announcing on this case, it's AF 126 South Oleander Residential Trust dated
And.
at 126
Right.
16 and
Right.
Stonegate Properties LLC.
Right.
Just so.
Okay. Thank you.
And this is before you for imposition of a fine. The inspector is Mark Jones. Mr. Jones reports that he's heard nothing from the respondent. The respondent did paint the building, he says, but he hasn't done any repairs. And he hasn't pulled any permits and there's no applications for permits on file. So we're asking for a $250 a day fine to be imposed to a maximum of $20,000.
Okay. So no repairs and no permits since the last time we were here. And this notification went out in August, last August, correct?
Yes.
Mr. Jones, do you have anything to add to this?
Nothing that
Okay.
we've had
And
no
we've given
contact.
them extra time because we had to renotice because of the name change or the additional name. So there has been extra time given already.
Yeah,
Okay?
this was the case in the redevelopment, wasn't Mr.
Yes,
Berger
that's right.
here
Mr.
last
Berger
time?
was here last time, right. Okay. All right. The chair will entertain a motion to impose a fine of $250 per day against the respondent effective today, April 12th, and continue until compliance is achieved or reaches a maximum of $20,000. Is there such a motion?
So moved.
Motion, Mrs. House, second, Mr. Weatherholtz. All in favor
Excuse
say
me,
aye.
was it 25,000 or 20?
25?
20,000.
It's 20
It's 20. All right.
because of the value. Okay. Did I say 25?
No, you
Okay.
said 20.
All right. All right. So Motion, Mrs. House, the second. Mr. Weatherholtz, all in favor, say aye.
Aye.
Like sign opposed. Motion carries. Case number 10, CEB 11-17-160, Rosetta Henderson. Anyone present? Working without permits at 785 Tennessee Street. All right. Mr. Jackson.
Madam Chair, members of the board, this is before you for imposition of a fine. The inspector is Mark Jones. Mr. Jones reports that this property remains in non-compliance, but the what does that say? Permit. Oh, right. That's the permit was issued on 3/12. Yeah, it was permit issued on 3/12, and the respondent also submitted a no rental letter indicating that they won't be renting the property, but they have the permit and just need to bring the rest of the property into compliance. The inspector is asking for an amendment to the next cutoff, and I tender Mr. Jones.
Mr. Jones, is the inoperable vehicle gone?
Yes, it has been removed.
The weeds?
The yard and everything has been cleaned up. The outside storage, the tenant has been removed from the property, and Ms. Henderson's planning on her intent, she said, is to move back into the home.
Okay.
And they have the permits to do the work.
Yeah, they have the permits have been issued after the fact permits. She just needs to get an inspection.
Okay. All right. The chair will entertain a motion to amend the previous order of noncompliance and allow respondent until May 2nd, 2018 to come into compliance and be returned to a subsequent meeting for consideration of a fine of up to $1,000 per day until compliance is achieved. Is there such a motion?
So moved.
Motion, Mr. Harrington, second, Mr. Jones. All in favor say aye.
Aye.
Like sign opposed. Motion carries. All right, case number 11, Khalil Land LLC, CEB 01-18-08, 1222 Essex Road. Respondent present. Okay.
Madam Chair, members of the board, this is before you for imposition of a fine. The inspector is Mark Jones. Mr. Jones reports that this property remains in noncompliance. The tenant has outside storage and parking in the yard. Now the owner has informed Mr. Jones that he is under contract with the tenant that's supposed to close in May, but it's not really all that relevant. It's as of today, it's in noncompliance, and in fact, the tenant is the one that's doing the actions that has not been remedied. So the recommendation of staff is $100 per day fine to a maximum of $15,000.
Okay. All right, Chair will entertain a motion to impose a fine of $100 per day against the respondent effective April 12th, 2018, today, and continue until compliance is achieved or reaches the maximum of $15,000. Is there such a motion?
I have a question.
What? Excuse me?
I have a question.
Okay, go ahead.
They do not have a license, either license. Can we not find them immediately on that, whether there's a contract or not?
There's no tenant in there, is there?
Yeah. Is there?
Oh, there is a tenant. Oh.
Oh, am I on the right case? You're looking at me like
11.
That's what I'm looking at. It says failure to obtain residential rental license.
Well, they do have their business tax receipt. They paid the
they have
license fee,
okay.
which they paid the fee, so that would eliminate
okay.
the business tax receipt violation. But they are in non-compliance and everything else.
All right.
Okay.
So those two things are done.
Yeah.
Okay.
Well, it doesn't take care of the rental license.
They don't have their rental license, correct?
That's correct.
And I think in cases like that, whether they're selling it or not, that part of it they could be fined immediately.
Well, if I may, I'm sorry, Mr. Harrington, our recommendation is that they be fined.
Right.
But the fact that they say they're selling it is just information.
Right.
But it's not
all
something
right.
that we're...
That solves that then.
Right. Okay, so the chair will entertain a motion to impose a fine of $100 per day effective today, April 2nd, 2018, and continue until compliance is achieved or reaches the maximum of $15,000. Is there such a motion? All right, we don't like that motion. Is there a discussion, please?
To me, it seems like an effort in futility. So often these are up for sale as soon as they're up for fines. And then the next guy buys it and asks for
the reduction.
To reduce it or eliminate it.
But he has to that next person has to bring it into compliance. So the building is actually in compliance.
I agree. That's
this
right.
One, they paid the business license, but not the rental, and it's still being rented.
Right.
So,
Are they still parking on the front lawn?
Yeah.
I mean, it's,
yeah, you saw pictures. Yeah,
they are.
yeah, well, that
Yes,
changes
still
from
parking on
day
the
to
front
day.
yard. And if you recall last month when Mr. Blake was here, the property owner, he was trying to negotiate a deal with the tenant. He was going to pay him to move out. And that's why we had granted him an extension before.
Right.
He notified me yesterday afternoon by email that he now has a contract with the tenant to sell the property to the tenant. But the violation still, until it still exists.
All right, so our option here is to fine him or not to fine him and we can decide how much. The city has recommended $100 a day, up to $15,000. We can change the amount per day or leave it at 100. So should I restate that motion, or do you want to up the?
I think up the ante a little bit.
Okay.
To
Go ahead.
$200,
$200
a day.
Okay. All right.
That's the motion? You've made the motion?
Yeah.
Okay,
all right.
I'll second it.
Impose a fine of $200 per day, as this is the motion, effective today, and can continue on until it reaches $15,000 or compliance is achieved. So a motion is made by Mr. Weatherholtz. Is there a second?
Second.
Second, Mr. Harrington. All in favor say aye.
Aye.
Like sign opposed. Motion carries. Okay. All right. Now, we could take a little break, and if there's anybody here, and I really mean a little break, like 5 minutes, no longer. If anybody's here whose case hasn't been heard, if you have a new case, you come up and please see our board secretary, June, and she'll let me then know that you're here and you're waiting to be heard, and we'll hear your cases first when we resume, and we'll resume right before 11 o'clock. Thank you. All right, the meeting will now resume. Call to order. All right, now, we're going to start our new cases, and the first one is and we're doing this to people that have checked in, but we're still going to go in order. CEV 0418-32, Mike Nelson, at 104 Maple Drive, and this is simply for compliance or non-compliance. Please come forward, state your name and address for the record.
Here we go.
Okay.
Mike Nelson,
What's your address, sir?
843 Loyola Drive, Ormond Beach.
Okay.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay. This is a new case, is this correct? A new case, okay.
New case.
At the same address?
Okay.
All right. Mr. Jackson.
Yeah, that's for sure you're a realtor.
Oh, God. I'm calling Mrs. Brown.
I'm sorry. I'm just trying to get my papers squared away here. Go ahead.
Yes, Madam Chair, members of the board, this is before you for determination of compliance or non-compliance. The inspector is Mark Jones, and Mr. Jones reports that the property is currently in noncompliance for failing to have obtained the rental license. And it is understood that the respondent has some confusion about what's needed, so I will tender Mr. Jones so he can make clear to you that that he does not have a rental license and one is needed.
Okay.
One question, is a piece of paper issued when you have a license? Then you either have a copy of the license or you don't.
Come on up, Mr. Jones.
Yes, that's correct.
Okay.
I met with Mr. Nelson at 104 Maplewood and informed him that he did not have his rental license. What he has is his business tax license and has had that for quite a few years. But he has yet to apply for a rental license or have a rental inspection.
All right. Thank you.
And I'm sorry, I don't know if I said it, but the request is that he be in compliance by next cutoff.
Okay. All right, Mr. Nelson, do you understand what they're telling you? We now have a law in place that says you have to have a rental license in addition to a business tax receipt. So you have to call them when your house is ready to be inspected, and they will come out and tell you what you need to do.
Actually, what I did, I called the Permit and Licensing Division and asked them what I need to do to get a rental
And
license.
so you understand, they told you what you needed
Yeah,
to
they
do.
told me the property is licensed as a rental property. I can legally rent it, and I don't need to do anything else.
Well, I think probably then you need to talk to Mr. Jones so he can explain it further to you, because you evidently what you have is a business tax receipt. So that I can't explain to you the difference. It's not up to us. But you also, what I do know is you need a rental license.
Yeah, actually, I do have it. Because
Well, where is it?
They have it there. They told me that it is basically the rental license. Now, I think there is a confusion that I'm going to try to clear it up, ma'am. I talked to Mr. Jones. It seemed Mr. Jones told me that he has tracked it in his system, and he didn't find the property to be the license as a rental property. But I don't know if his system is the same thing as permit and licensing, because permit and licensing, they check, the lady that basically checked it is Miss Melissa Carter.
What they're telling you is that you need to get your rental license, and to do that, you have to have an inspection. Have you had an inspection?
Of course. I originally filled out an application, and there was an inspection.
We're going to have to hear from Mr. Jones for a second. Has Mr. Nelson, to your knowledge, has Mr. Nelson applied to have a rental license and an inspection?
Not as of this morning. Before I came over here, I checked.
Thank you.
Mr. Nelson, do you have a file on your property in which you keep copies of inspections and licenses? Do you have such a thing? Yeah. Because normally somebody coming in here would say, I have a rental license, here's a copy of it. You never seem to produce these things. Where is the copy of the rental license you say you have? And they issue you a paper copy of the license.
Originally, when I filed the application, and then they did the inspection, and all they issued to me was a copy like that. And they told me this is basically the certificate for that you paid the tax, and that it is for your rental license. That's what I was told.
Is that for?
And actually, what you can do, I think this is, of course, my recommendation. You can just call right now Miss Melissa Carter and verify that.
It's a business tax receipt.
So it's not a rental license receipt.
You don't have a rental
It'll say rental license on it.
This is for this year, and the other one is for the previous year. And this has been going on since 2011, for 7 years. This has been a rental property.
What I'm in possession of here and looking at is a business tax receipt.
Not a rental
It
license.
says BT on it, business tax
Yeah,
receipt. You're right, you're correct. You have a business tax receipt. What you don't have is a rental license. So now we're going to rule on this. And you need to get with, if you don't understand this, please talk to Mr. Jones and he'll explain to you how you can get a rental license for your property so you can legally rent it out.
It's two separate things. It's
right.
not the same thing. It's two separate things. Does that make sense?
Then I called them and I talked
Well,
to...
I know, but so evidently there was some miscommunication. So in order to straighten that out, please talk to Mr. Jones, and he will explain to you what you need to do. Thank you. The chair will entertain a motion to find respondent in noncompliance and order respondent to come into compliance by the next cutoff date, May 2nd, or be returned to the board for consideration of a fine of up to $1,000 a day.
So moved.
Mr.
Second.
Jones made a motion. Mr. Weatherholt a second. All in favor say aye.
Aye.
Like sign opposed. Motion carries. All right, now let me see what we have. So that was case one. Now we have case two. CEB 041833, Zach Foster at 606 South Peninsula. Come forward, Mr. Foster.
Zach Foster, 606 South Peninsula Drive. Same.
Okay.
Yes, ma'am, I do.
Okay, thank you. Let me hear from Mr. Jackson and Mr. Reckenzon if need be. Mr. Jackson.
Yes, Madam Chair, members of the board, this is before you for determination of compliance or noncompliance. The inspector is Cliff Reckenzon. Mr. Reckenzon reports that the property is remains in noncompliance. His communication with the respondent believes he can have the boat in the driveway, but that is contrary to the code, and so I would tender Mr. Reckenzon if you have any factual questions.
Okay. Don't think so. We can see that the boat's still in the driveway. Mr. Foster, what would you like to say about why you think you're in compliance?
I don't know if this is germane.
Okay.
I have a few months ago, I got this information. I called the gentleman several times. I couldn't reach him. I was in and out of town. Nothing seemed to happen. I didn't mean it to get this far. I realized, according to my neighbors and myself, I figured that they had re-examined it and figured that there was no problem with the boat. I thank you all for your consideration to this situation. Not that it makes any difference, but I was born in that house in 1939, cool. And through the 50s and high school and when I started college, I kept the boat there. I never had any problem. I came back to Daytona in the 1980s to take care of my mother, who had problems. And the first thing I did was buy a boat. Like I say, I've had it there since the 80s. Now, I've heard from a friend of mine that's a commissioner that you all have gotten stricter on code enforcement, as you should. I agree with it 100%. I've seen a lot of junk boats around, a lot of junk in people's yards. But my house, I'm 50 feet back. I like a lot of trees, as you can see. Yeah. The only time you can really see the boat is when you're when you're coming down Braddock into the driveway. I surf occasionally now. I was third in the United States in the early 70s. Water skiing and tennis are big parts of my life. I try to keep myself physically healthy, pushing 80. That's not easy. As of my my mind, that's up to you to judge. My memory isn't what it used to be.
We're not here to do that.
I'm just saying that
we all have issues.
I mean no harm to you all.
No,
this is my town.
We understand.
I love it. We've been here since the 1890s, and I don't mean any harm. I just know that if I have an issue with my teeth, it's going to cost me a small fortune. And at my age, money isn't coming in like it used to.
right,
I've
sir.
had a boat a good part of my life. I hate to have to get rid of it,
Right.
but with all due respect, I don't think I can afford to keep it if I have to move it. So that's
Well,
going to be a good
you-
part of my life.
If you will get with Mr. Reckenzone, I'm sure that he will tell you what your options are. It doesn't have to leave your property. It just can't be in the driveway.
Well,
I'm
I
just,
wish
I'm
I-
just saying that. So if you get with Mr. Reckenzone, because the rules have changed, and you can't have a boat in your driveway. So if you get,
I couldn't be grandfathered into that.
no, they don't. No, I don't think so.
Can I
I don't know. I can't give you advice.
Can I just ask a question?
Go ahead.
The boat's 50 feet off the road. Could he surround that boat with a 6-foot fence and nobody would see? Would that?
I don't know.
I would love to get
I
it.
don't know whether that would.
I
I'm
would
just
love
curious.
to do that if I could.
Is that allowed so
Well,
that
the-
nobody
wait-
can see the boat?
The pictures, I have the pictures.
I know.
I'm just curious
I
as
know.
to whether
We
that
see.
could
Sir, there you can see
satisfy.
it.
So you.
It was, I might add, it was almost invisible before the hurricane.
Yeah.
And that cleared away some
Yeah.
of the brush, some of the tropicals that I had growing there. I like trees. I like birds. I don't poison my grass.
If I may,
Go ahead.
Mr. Jones, as Ms. Kundick said, I agree with that. I'm sure Mr. Reckenzone would be happy to get with him and see what his parameters are and whether or not that's
Right.
a possibility or what the
Whether there's,
possibilities are.
yeah, whether there are some.
You know, some maybe. 'Cause I know up in Tallahassee, a client did that for me. That he was allowed to put something up so nobody could see it. So maybe you
Yeah,
could.
we'll take a look, see if there's
Okay,
something.
okay.
It's
All right.
a great idea, Mr. Jones. I would love to get a permit. and
Okay,
put a
well,
fence.
we'll see. Okay, well, you work with Mr. Reckenzone. I'm sure he'll work with you. Okay? So we're going to, I'm going to entertain a motion to find respondent in noncompliance in order the respondent to come into compliance by the next cutoff date or be returned to the board for consideration of a fine of up to $1,000 per day. Okay, I'm going to do something else, I think.
That's what we usually do, right?
Tallahassee.
I did it.
I don't have that many options at this point.
Yeah.
Quarantine.
You know, it seems like $1,000 for the boat.
Well, if that's up to, it's up to, we can do 5. Change that. All right, so we're having, so I think that those are really, I don't know of another option in this case. Hopefully something can happen before the next cutoff date.
Couldn't you reduce
Or
it
we could,
dramatically?
Do you have to?
2 months. 2 months. Give them 2 months to get this settled. All right, here it is. The chair will entertain a motion to find respondent in non-compliance in order to respondent to come into compliance by the June 6th cutoff date or be returned to the board for consideration of a fine of up to $1,000 per day. Is there such a motion?
So moved.
Motion, Mr. Weatherholtz. Is there a second?
Second.
Second, Ms. Purdy. All in favor say aye.
Aye.
Like sign opposed. Okay, so we've given you 2 months, sir, to try and work out with the city what you can do to fix this problem.
Very nice of you.
Okay, thank you.
Very considerate.
Okay.
That's more than enough time. Thank you.
Okay, good. All right, case number 15. We don't get complimented like that very often. Case number 15, CEB 0418-34, Schulte Avenue Rentals at Schulte Avenue to 2031. Please come forward. And if I mispronounced it, I'm sorry. What's
Schulte Avenue.
Schulte Avenue, okay.
Yep, Kenneth Bogdan.
Kenneth what?
Kenneth Bogdan, and the address is at the 21 Schulte or
Okay.
4230.
Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay, we're just here to see whether you're in compliance or non-compliance, whether you have your permit or not. Okay? Mr. Reckenzone. Oh, no, Mr. Jackson.
Madam Chair, members of the board, this is before you for determination of compliance or non-compliance. Mr. Reckenzone reports that a permit was issued yesterday, and it just needs to be finalized. We're asking for next cutoff for there to be compliance. And I attend to Mr. Reckenzone.
So what you're saying is he applied for the permit, and he should have it by the next cutoff.
I do already.
You already have it, all right? He's testifying that he already. All right, so how can we find him in non-compliance if he has the?
Until the permit is finalized.
Okay, all right. So
It has to be processed.
This is just going to be like housekeeping and keeping things in order for us. So I'm going to ask the board to entertain a motion to find respondent in non-compliance in order the respondent come into compliance by the next cutoff date, which is May 2nd, or be returned to the board for consideration of a fine of up to $1,000 per day. Is there such a motion?
So moved.
Motion, Mr. Weatherholt, second, Mr. Jones. All in favor say aye.
Mr. Jones
Like sign
didn't say
opposed.
anything.
Motion carries. So you have your permit. They just need to do the final approval of it, and then this is done. Yeah, okay. That's okay. Well, whatever needs to be done, get with Mr. Reckenzone, and he'll tell you, and then this will be fine. All right, now we're at case number 16, CEB 041835, Susan Hancock, 613 Holmes Avenue.
When? Last month.
I can't afford to do that.
Well, you don't look like Susan, so who are you?
Marcus McDonald, 1962, Red City Circle, South Daytona, Florida, 32119.
I didn't say anything about the cost. I said
Yes, ma'am.
So what is your relation to Susan Hancock?
She's a good friend of mine.
Friend, okay. And you have permission to speak for her?
Yes, ma'am.
Okay. Thank you.
I'm sorry if I could, although I don't think it's going to affect what we're doing. I don't think it's going to affect what we did today, but you said you have permission. Did she give you something in writing or something?
Nothing in writing.
So you're not speaking on her behalf, but you do have something you want to say concerning the property.
Okay. Right. Just witness. Okay.
Yeah, Madam Chair, members of the board, this is before you for determination of compliance or non-compliance. This was based upon a tenant contact. The property right now is in non-compliance. Okay. Yeah, it's a non-compliance, and the inspectors, Cliff Reckenzone and Mr. Reckenzone, recommends that you give the respondent until next cutoff to come into compliance. I'll tend to Mr. Reckenzone for any additional factual information.
Okay. Mr. Reckenzone, have you had any contact, or what is it?
I had contact with the tenant on the day that I noticed the violation.
Uh-huh.
She did not believe that the violation was true. She told me to send her a letter, so I did.
She didn't believe that it was what?
Oh, she didn't believe that it was a violation.
Oh.
So she told me to send her the letter, so I did. And she made contact with me after the letter. She told me that she wasn't going to move the car. She had no place to park it, and that I should take her to court.
Okay. Thank you. All right, as a friend, what would you like to testify to?
Well, I'm the owner of the property next door to it, which is the next case, 609 Homes. And I have talked to Mrs. Saunders. She is the tenant living there. And she apologized for the way she talked to Mr. Reconcile when she saw him. And she had family members living there that weren't supposed to be living there on the lease, and she said she would get in compliance with that.
Okay. We know how to get in compliance with that, correct?
Yes.
You just move the car. Okay, yeah, okay. Do we need anything else?
No, just finding a non-compliance the next cutoff.
Okay, yep.
Madam Chair.
The chair will entertain a motion to find respondent in non-compliance in order to respond to come into compliance by the next cutoff date, May 2nd, 2018, or be returned to the board for consideration of a fine of up to $1,000 per day. There's such a motion?
So moved.
Motion, Mr. Harrington, second, Mr. Jones. All in favor say aye.
Aye.
Like sign opposed. Motion carries. All right, we're going to move on to case number 17, CEB 041836 MKVY Enterprises. Come up again.
Yes.
You're going to have to state your name again. Well, I guess not, right? Does he have to be sworn in again? No? Okay, all good.
Marcus McDonald.
Okay.
Okay, thank you. And 609 Holmes Avenue is the property I own, and they also had family members living there that wasn't supposed to be on the lease.
Okay.
And Mr. Reconcile, he explained to me how that they are allowed to be parked, just not in front of the structure, but they could be parked parallel. So I explained that to them, and they were willing to cooperate with that.
Okay, good.
So we merely need non-compliance next cutoff, Madam Chair.
Okay.
I'm not sure what parallel means.
Yeah, I don't know what that
I think you meant on the off-road.
On the
right of way.
On the. I'm trying to get on the picture there. You see where the mailbox is?
Yes.
Anything from the mailbox to the street is actually city right away.
Yes.
Right.
And they can park on the city right away there.
Okay.
And that's acceptable.
Okay. Good.
Does it, let me, this.
As long as what, did you say, sir?
As long as it's not for more than 24 hours at a time. Then it can be ticketed and towed.
Okay.
Does it have to be, since it is a mowed area, and this has come up quite often, that it's allowable for not more than 24 hours, but if they would put some type of gravel or pavement.
I think you have to get a permit to do that, don't you?
Yes.
Well, you see quite a few vehicles, and they've right in their right of way. They have it cleaned up with gravel.
And I think that's an issue because in the past, that river gravel is not an acceptable. They have to have something concrete.
But
Okay.
you have to have a permit to put it in the,
Probably.
in the right of way.
All right, so this is not anything we can solve here for you. It's a city issue, really, and the rules are the rules, and we're here to kind of say whether you're following the rules or not following the rules. We don't make the rules. But if you get with, I'm sure you've talked to Mr. Reckenzone about the other case, so this will be fine too. So the chair will entertain a motion to find respondent in non-compliance and respondent come into compliance by the next cutoff date, May 2nd, 2018, or be returned to the board for consideration for a fine of up to $1,000 per day. Is there such a motion? Motion, Ms. Purdy. Second, Ms. House. All in favor say aye.
Aye.
Like sign opposed. Okay, thank you. All right, so 18's in compliance, 19's in compliance, 20 is in compliance. All right, now we have case 21. I know somebody's here for that. Silverleaf at CEB 04-18-40 at Bada 4.
State your name and address.
Teresa Valdez. I represent the owners for 130 Butterford,
And your address.
3 Cormorant Circle.
Raise your hand. Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Just have a seat, and we're going to let Mr. Jackson and Mr. Reckenzone tell us what.
Just one. In what capacity do you represent? You said you represent.
I represent the owners as the property manager.
Oh, okay.
You're the property manager? Okay. All right, Mr. Jackson.
Yes, Madam Chair, members of the board, this is before you for determination of compliance or non-compliance. The inspector is Cliff Reckenzone. Mr. Reckenzone reports that the property remains in non-compliance. And that he indicates that the outside work, most of the outside work is complete, but he hasn't been able to see inside to see how far along they are on what needs to be done on the inside. But nevertheless, it is in non-compliance, and he asked for them to be in compliance by next cutoff.
Okay, now this just is number 3, 130 Bada 4, number 3. Is this just one unit we're talking about?
I believe the case was, the number 3 was improperly put onto the case, but they understand that it was the entire building.
Okay. Well, insect screens, it's not just the screens at number 3.
Correct.
And it's not heating facilities, not just at number 3.
Correct.
Okay. But number 3 is included
Correct.
in that. Okay, so that's good to know. All right, would you like to tell us something, Ms. Valdez?
Well, the day when Mr. Cliff came on the property was my first day on the job.
Okay.
So, welcome to the job. But at any rate, even though the allegations of what is missing was for number 3, was because it was the tenant at number 3 that called because of various personalities between the tenant and the ownership. Okay, but since then, I can prove that we have taken every recommendation that Mr. Cliff has made to apply to the entire building. So all the insect screens in every unit have been replaced. All the windows have been replaced. As soon as we put in a new window, another one gets broken, but that's life. That goes along with the job. Okay, I understand that. And there was a question about a leak of water on number 3 that was coming from the second floor. So I hired 2, no, it's not there, but I'm telling, I hired 2 certified plumbers to come and tell me the nature of the problem. They were able to come up with a solution, which we think is a solution, and we had that remedy on B6, which is the unit above number 3. And since then, there have been no further problem with that unit. We have since totally redo the inside of number 3. It looks very nice, and I think I might even be able to go up on the rent in number 3 now. But go ahead.
How many units are there in this building?
There's 8 units in that building.
Okay.
The other issue was one of the heaters. He questioned, he put one heater, but we're looking at all of the heaters, okay? And I have had a licensed electrician come and check.
All right, so what I understand is that you've done some of the work on this, and
we're not finished by a long shot.
Okay, so when you are finished, you need to get with Mr. Reckenzone so he can come back.
Certainly.
And look at that. And how long do you think it will take you to get all this work done?
I have an electrician that have given the okay on all the heaters.
Okay.
But the exterior of the building needs to be pressure washed and cleaned, and just so that it can be.
Yeah. Okay. But all right. But just for these issues that are on here, so I think that
I would be able to ask Mr. Cliff to come over and recheck the building and see what else are we out of compliance with.
Good. Thank you for your cooperation. That will be wonderful. So. Well, I will entertain a motion to find respondent. The chair will entertain a motion to find respondent in noncompliance and order the respondent to come into compliance by the next cutoff date, May 2nd, 2018, or be returned.
Oh, can you make it a little longer than May 2nd? The thing is...
Okay, hold on. Just wait a second. You don't have any objection to making it June 6th?
That's good.
Okay.
That's good.
All right. June 6th, 2018, or be returned to the board for consideration of a fine of up to $1,000 per day. Such a motion?
So moved.
Motion, Mr. Harrington. Is there a
Wait,
second?
we don't have to pay $1,000?
No. Okay. No, it's only if the work doesn't get done.
Only if you want to.
All right. Thank you very much.
Okay, we have to vote on it now. Wait, we had a motion from Mr. Harrington, I think a second, Ms. Purdy. All in favor say aye.
Aye.
Like sign opposed. Motion carries. So you have until the 6th of June to get this work done.
But I can call
You can call Mr. Reckons on whenever you want him to come look at the property or whenever you have a question.
Okay.
So you know that you're doing the right thing, okay?
Thank you very
Thank
much.
you.
Mrs. Valdez, are we going to see you on the ballot this year?
I would love to.
You're not running.
But I'm 83. It's time to let somebody else do the job.
Okay.
Hopefully.
All right. Thank you. Next case, 22 CEB 0418-41 Ayunta Properties.
Hi, hello.
Hello.
Anjali Khurana,
Ayunta.
2967 South Atlantic Ave, Unit 1506.
Do you solemnly swear or affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
What is your name?
Anjali Khurana,
And what is your relation to?
Jia Khurana. I'm the daughter of the owner
Okay.
of Ajanta LLC.
Oh, that's all it is.
It's all right.
That's all right.
You're speaking on his behalf.
Yeah, on her behalf, yes. Yes,
Okay,
my
so
mother.
you're speaking on her behalf.
Yes,
Okay.
I am. I've also been working with her to get these things done.
Okay.
All right.
All right. Mr. Jackson.
Madam Chair, members of the board, this is before you for determination of compliance or noncompliance. The inspector is Cliff Reckenzone. Mr. Reckenzone reports that the property is currently in noncompliance. The building needs to be painted. The paint has not been done yet, and there's been no permit for window repair. Those are the two issues. So Mr. Reckenzone recommends that you make a finding of noncompliance and that you give them until next cutoff to come into compliance. I tend to Ms. Reckenzone if you have any factual questions.
Let's see.
It's,
Go ahead.
it says here, damage to the outer wall, exterior wall.
Yeah, that's the repairs. See that?
There are some shingles that are missing. It's a shingle
Right.
building,
Okay.
so they have to replace the shingles.
I mean,
Paint-
it's no structural or anything.
No, nothing like that.
Okay. All right. What would you like to tell us, Mrs.
Okay, so we have been trying to get a lot of repairs done. So there's the painting, the windows, and the shingles. And this has been going on for some time. My mother was getting the repairs done and had a string of, I would say, unsavory experiences with contractors and people working. So she got one person to come in to change the windows she paid for windows from Lowe's, got him to come in. He brought larger windows, cut the opening so that it would fit, and then he never came back. That was the first experience. Second time, she brought somebody else, again, got some new windows. Someone came, said they would do the work, didn't show up. A third person came in, recommended windows from Habitat, so she paid for those as well. He came, and he didn't show up. So then we're from Cambridge. I have been working abroad for the last several months. I came back into the country just to help my mom get these sorted because she was just very overwhelmed with everything that needed to be sorted. All of these damages came after the hurricane, and so, of course, unexpected. So I came in November to get this done, and we went to Window World, thinking, okay, this is a reputed company. We shouldn't have any issues. We talked to Corey from Window World, signed a contract with him. He said that because we would be changing just a few of the windows, under 25% of the windows, that tempered glass windows would be the way to go. He went ahead and applied for a permit, and then it turns out that those aren't the right windows. But he's already installed them, and he has gone ahead and revoked the permit, even though he's done the work. So now, yeah.
Yes, please.
I apologize to the board. The inspector had given me an updated note that included the information regarding the windows. However, the circumstance is that the windows, at one point, they thought it was resolved, and I think that's part of the story that she's telling. And then ultimately it came back, so he removed that as the violation that he sent before the board. Okay. So the only thing the board's really considering is the issue regarding painting, because he has not sent before the board
All right, so let's
the
get
issue
back.
concerning the windows.
All right.
When I came in November, I just basically tried to get everything done at the same time. So a lot of the times, prior to this, when my mother was getting people to come in to do the windows, she was also trying to get them to do the painting, but they just weren't coming back. So when I came in November, we sorted out this contract and got somebody else to come in to do the painting and the shingles. But because it was November, they all said, we'll do it after the New Year, so post-Thanksgiving and the holidays. So that all happened. The permit, as you said, it's been revoked. So now we're basically going to have to appeal this, go through a case with Window World, because we have these windows that aren't compliant, but they're installed and they're not willing
For
to.
our purposes, what we need you to get done, and I'm sure Mr. Reckenzone can tell you this, is paint
And the shingles.
repair.
Yeah. So those, I just got back again to take care of this. So like I said, I've been working abroad. I got back on Saturday just to take care of this stuff. So I'm trying to look for a new contractor, a new person to work on this. And I'd like to say that it'll get done tomorrow, because ideally that would be a big headache off of my mind and off of my mother's head. But I don't know exactly how long this is going to take, given the history. And even we had someone who came and painted. He painted the back of the house and then didn't come back.
Who lives in the building?
They're tenants. It's on rent. Mm-hmm. So we've just had a string of very bad experiences, but we are working to get someone to do it. It's not that we
All right,
don't want it to be compliant.
But you are in non-compliance, we can see from the pictures.
Yes.
Even though you're working to get into compliance, we're going to find you in non-compliance.
Right. And I guess my question or request would be, if we can get additional time to get this done. I am here for that purpose, to help my mother get these repairs underway. So I do realize that it's urgent, and that's really what I've come back for anyway. But I just feel like we might need a little time on it.
Is the city amenable to that? We could order a progress report.
Madam Chair, the inspector, as I said, he hadn't brought the window issue back, before the board. As to the painting or the repairs to the outer wall, the inspector feels that the next cutoff is reasonable time. He would be happy to consider, if they're making a diligent effort and they're having challenges with contractors, those types of things, bringing that before the board if they have to come back and agreeing to the extended time. But he believes he's giving reasonable time.
Right now, today, the next cutoff date. Okay. We got to get some things in motion here, because this was in September, and I understand how difficult it is with contractors, and we all have those issues too, but we need to get moving on this. So what we're going to do, the chair will entertain a motion to find respondent in noncompliance in order the respondents come into compliance by the next cutoff date, May 2nd, or be returned to the board for consideration of a fine of up to $1,000 per day. Is there such a motion?
So moved.
Motion, Mr. Weatherholtz. Is there a second? Second. Second, Ms. Purdy. All in favor say aye.
Aye.
Like sign opposed. Motion carries. Now, if you come back, and we hope that you will make substantial progress on this in the next month. That's what we're looking for.
Okay.
You're leaving
For
the country, aren't you?
Not until June is what I was.
Okay.
I was hoping to get it done in the next 2 months.
I thought you said you were leaving. But okay.
No, I just got back on Saturday. Still jet lagged.
Okay.
So that is for the painting and the shingles. We're not talking about the windows.
We're not talking about the windows at this point. Okay. All right. Thank you.
Thank you.
All right. Case 23 is in compliance. Case 24, CEB 041843, Clinton and Margaret Smith.
What does no permit mean?
No permit. Yeah. Don't know.
There's 2 cases with no permit.
No permit, no permit. This is at 636 Fremont. Good question. We will hear. Please state your name and address for the record. Good
Barbara
morning.
Smith, 636 Fremont Avenue, Daytona Beach, Florida.
And Margaret, okay.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Oh, I see what.
Well, we can kind of see. All right. Mr. Jackson, please explain to us what no permit means. For what?
It's no permit for, is that the one for stairs? What is it for? It was a structure. Okay. Yeah, well, let me get to it. There we go.
Okay.
Madam Chair, members of the board, this is before you for determination of compliance or noncompliance. The inspector is Mr. Reckonsone, and he reports that the permit is under review.
So a permit has been applied for?
Yes, and the structure has been removed. So we're just asking for a finding of noncompliance and next cutoff form to come
What
into
is the
compliance.
permit for?
I would have to tender
Okay,
to
all
Mr.
right, okay. It's just
Reckonsone.
confusing to see no permit, nothing else, so, hold on. Go ahead.
They were building this exterior structure in the backyard,
Okay,
and she has removed the structure.
I
and
see.
it's no longer there, and the permit is under review now.
why would, if there's no structure there, what does she need a permit for
If she wants to rebuild,
if you want to rebuild? Okay,
which I'm under the
Okay, I get
assumption
it.
she does.
okay. And it's been applied for?
Yes.
Okay.
What's the structure
The
for?
structure is for, we wanted to extend our deck. We already have a
It's
existing
a
deck
huge
there, we
deck.
want to extend it. So we started and he stopped
Okay.
reviewing.
You
I
had
went and
stop
I
work.
got
Yeah.
everything that I needed. Now,
That's a deck?
I have a pool deck. You can't see it right there, but that's extending it out to the property line. So they stopped me from extending it out.
It's a deck with walls and a roof?
No, it's just the deck, because that's the back of the property line, so it comes out to where we started building the extension, and it's above ground deck wrapped around the pool.
Well, what's the structure standing up?
That was gonna be an extension we was gonna frame it in.
To do what?
Wrap around a pool, all the way around.
A building?
No.
No, what? We don't understand what, the question, I think, is about the fact that that looks like a structure for walls.
Right, it was gonna have two walls, one this way and one that way.
It's a deck.
With a pergola over it.
Okay. Go ahead.
But the inspector indicates that's what's been removed, so that's not there anymore.
Oh, so that's not even
It's
there?
not there anymore.
Okay.
Okay.
So, and you have submitted and applied for the permit for whatever you'd like to do back there?
Yes.
And it has not yet been approved?
Correct.
But it should be approved sometime soon, correct? Okay.
Yes, because I got an architect to draw
Good.
it up.
Okay, terrific.
Get it.
Okay, so what, Chair will entertain, do you have any other questions here? Chair will entertain a motion to find respondent in noncompliance or respond to committed compliance by the next cutoff date, May 2nd, or be returned to the board for consideration of a fine of up to $1,000 per day. Is there such a motion?
Well, I think she is in compliance. It's been
No,
removed.
the permit hasn't been approved yet. She's applied for it, but it hasn't been approved. Correct? Is that?
That's not how I'm understanding it.
Yeah,
Am
she
I
took it down.
incorrect?
Yeah, she
Took
took
it down. Right.
Oh, yeah, okay. I see the
There's
dilemma.
nothing there to, yeah, if she starts building again without a permit, that's a different story.
Right. True. Thank you. Makes sense to me now.
So it's in compliance until it isn't again.
I would say that. I mean, I see how that's a big question. Go ahead.
Well, after
Mr. Jackson.
after conferring with staff, we agree. I think that's a fair conclusion. It is down, and at this point, until if she follows the steps, get the permits, and move forward, there's no violation here.
Okay.
So we would agree.
So, okay. So
we'll call it a withdrawal. We should have withdrawn it before we got
withdraw.
started.
Okay,
Yeah.
they're withdrawing that right now, so good luck with whatever you're doing.
Thank you.
Okay. Case number 25, CEB 041844, JFK Capital LLC at 520 Vermont. Thank you for waiting all this time, sir.
He has no permit.
Could be more.
And yours is another one that just says no permit, so.
I learned a lot from this right now. 205 Slade Drive.
What's your name?
I mean, that's my house. First time I'm in this situation. 520 Vermont, Clever Panora.
And your name?
Clever.
C-L-E-B.
Clever with a K.
K-L-E-V-E-R.
Yeah.
Do you solemnly swear or affirm that the testimony that you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, we will let Mr. Jackson and Mr. Reckenzone tell us about this no permit.
Yes, Madam Chair, members of the board, this is no permits for stairs that were installed, as you can see in the photos. The inspectors, Cliff Reckenzone, Mr. Reckenzone recommends that you give the respondent until next cutoff to come into compliance. He has permit, but he has to get it final before the case will be closed.
So he needs a final inspection?
Now, I'll have to have...
Okay, Mr.
Yes.
Reckenzone, what do you need to get this into compliance?
The permit was approved yesterday.
Okay.
And they just have to call for a final on the permit. And once that final is done, I can close the case.
Okay. All right, so we're going to entertain a motion to find respondent in noncompliance or respond to come into compliance by the next cutoff date, May 2nd, 2018, and be returned to board for consideration of a fine of up to $1,000 per day. Is there such a motion?
So moved.
Motion, Mr. Harrington, second. Ms. Purdy, all in favor, say aye.
Aye.
Like sign opposed. So you have till next month to get with, till May 2nd, to get with Mr. Reckenzone and get it inspected, and when that passes, then it's finished. Okay, thank you very much. Sorry you had to wait so long. Okay. Any miscellaneous business?
Ms. Purdy might.
Ms. Purdy, thank you for your service. That was too short. It was too short for us.
Have you resigned?
She's moving.
Okay.
Oh.
Just making sure.
Oh, wow.
Yeah.
Tony, my board had mentioned they'd like to have a workshop, but I think we would wait till after the new person comes on board.
You might as
Yes.
well now. too.
Yeah, right. I know we had talked about it. Yes.
Is there some, we have applicants for the new board?
I don't know. I haven't